Can everyone hear me good? Everybody good? Okay, we want to call a general meeting of the Kentucky Horsemen's Benevolent Protective Association to order. I want to announce to everybody here, this is being recorded live. It's being put out on YouTube. It's being Zoomed across the country. We have several people out watching this on Zoom. So I ask that you would be calm and respectful in your comments, and we will get to each of your questions and stay as long as we need to. I'm Rick Hiles, the president of the Kentucky HBPA. In case some of you don't know, I have with me today Marty Malign, who is executive director of the Kentucky HBPA. I have Eric Hamelback, who is the CEO of the National HBPA, of which I am also the vice president of the National HBPA. We have Peter Ecabert, which is our general counsel, and we have Lisa Lazarus, who is the CEO of Horseracing Integrity Safety Act. And please keep in mind that Ms. Lazarus is just in a position of trying to do a job. It's not; these are not her rules and regulations. She's just part of an organization that she's trying to oversee. So be respectful to her as we go along. And I want to let her make a few comments if she'd like before we get started to the audience, please. Lisa.
Hear me now? Oh, yes, that's great. So first of all, I just want to say hello and thank you for inviting me to speak with you today. I'm really happy to be here. The horsemen are obviously incredibly important to HISA. And I thought I would start by saying maybe a few words about our mission and also about my background. So I'm sure you all know that HISA came into effect in December 2020, and it actually was passed in December 2020. Its effective date is coming up on July 1. Our mission is really twofold. It's to enhance the safety of the sport for horses and for the humans that ride or care for them, as well as the integrity through our anti-doping medication control program. That's our only mission, and that's what we care about. And we genuinely believe that once we take effect and you see the things that we're trying to do, that we're going to make racing better for everyone. That's really genuinely our only mission. We may disagree about how to get there, but that is what we're trying to do. We're trying to improve the sport. We're trying to elevate the sport. And I know here in Kentucky, you have a phenomenal sport, and national uniform regulations, I think, will be good for Kentucky. And I generally believe that if we do improve the sport, Kentucky is going to be a tremendous beneficiary of that, given how important horse racing is to Kentucky. And some of the key, as I'm sure you know, advocates for HISA were, Kentucky legislators like Senator Mitch McConnell and Congressman Andrew Barr. So I also want to say a few things about me, because I do think it's important that you understand who I am and what my philosophy is. Prior to accepting the position as CEO of HISA, I was a partner in a law firm where I represented horsemen in the sport horse world. So I've represented horsemen in doping cases, I've represented horsemen in equine welfare cases. So I've seen that perspective. And the one thing you will always have in me is somebody who will listen, who will hear you. And I will stay here as long as we need today to answer every question. If there's something that's particularly technical and I need to consult with somebody else, I'll let you know, but I intend to answer every single question for as long as it takes. Anybody who wants my card can have my card and can email me or call me. I answer every horseman that reaches out to me. It may take a day or two, but I answer everyone. And what I just simply ask that you give HISA the chance to work and to be effective, because at this stage, it is federal law and it is what's happening. And I think if we cooperate and work together and listen to each other, it's going to genuinely be invaluable for all of us. So with that, I won't waste any more time on me, and I'll be happy to answer questions or pass to Eric or Peter if somebody else wants to speak.
Yes, and then we're going to let Eric Hamelback make a few little statements, and then we're going to get into some questions and answers. I know all of you have concerns and questions you want to ask, and we're going to get to all of you, but I want to do it orderly and one at a time by raising your hand, and we'll bring a mic to you and try to get you answered all your questions. So Eric, if you want to say something.
Thank you, Rick. We appreciate everybody showing up here today. I always laugh and open up that we've all come together now to meet for that favorite new four-letter word, HISA. The Horseracing Integrity and Safety Act is here. We do understand that it is law. We do understand that President Trump signed it in December of 2020. We also do understand, in our opinion, that we think that there are some things that are unconstitutional about the law. And we fought so far and continue to fight very hard to make sure it's the right thing to do. One of the very promising things about Ms. Lazarus, and appreciating her being here, we always kind of open up with our conversations with, we put the lawsuits aside and we deal with the problems that she is in control of. And I know she's not in control of the lawsuits, and that's fine. But we are here to try and help with some of the implementation. I don't think that there is anyone that would disagree that there's a lot of problems with the implementation at this point. They have a tremendous undertaking that they are trying to accomplish, and we'll go through some of that. There's a lot of questions, though, that are going to get asked, that have already been asked, in many cases multiple times. You know, I've been fighting this position since 2015, before I was at the HBPA. And I've always said, in my opinion, while early on people disagreed with me, this law wasn't a problem because of Lasix. And everybody wanted to stand on Lasix. It hasn't been. In 2015, I sat still on the board of trustees at TOBA. Sitting to my right at the time was somebody who I think a lot of, Dr. David Richardson, who was a great man, still is a great man in my mind. There was a presentation on this new bill at the time, didn't have the safety aspects to it. His first question from the room, how is this going to be funded? That's what he asked. And I jumped on that, and I've been on it ever since. How are we going to fund it? I know now how it's going to be funded. It's going to be funded from all of you and your owners. That's how it's going to be funded. So we need to address the concerns. We need to look at the problems and try to help. In my opinion, long before Ms. Lazarus was in her position, we didn't get asked. Everybody knows the structure now, right? There's a nominating committee that was appointed. Who in here voted for anybody on the nominating committee? Nobody. There was an authority appointed. Who in here voted for the authority members? Nobody. Two subcommittees. Anti-doping medication control and the safety committee. Anybody in here vote on anybody that sits on those committees? Nobody. So in my opinion, which remains the same, they needed to ask the people in this room what was important. Owners, trainers that are in this industry. I respectfully never will call it a sport. We are in an industry. The people that do this every day, my good buddy Keith Crupper back there that does it every day, and many others in this room, that's who needed to be at the table. And I think, quite honestly, there would have been a lot less confusion when it comes to implementation if we could have agreed on how to get to that point. So for me, today's about question and answers. I will say we're going to try not to spend a lot of time, as Rick said, on registration. They have done town hall meetings, thankfully, across the country. I think I've sat in on 6 of them now. There's still a lot of problems with that. I know that Ms. Lazarus understands that, and they're certainly trying, but trying and getting it done by July 1st may be impossible. So with that, I'm going to give it back to Rick, and we'll open up with his questions, and then we'll start to go. I'll have a few questions direct and then open it up to the audience.
Okay, like Eric said, the registration process, though it's been cumbersome, we have people that can help you on the side besides this meeting. This meeting is really not about registration. We can take care of that for you. Any help you need at our office over across the street.
And can I just make one quick comment on the registration? Just so everyone knows, as of today, we have 25,000 people and horses registered. So we're actually at the benchmarks that we need to be at in order to have everybody registered who wants to race, intends to race by July 1.
Okay. And Lisa, one question I had about that is, I understand on July the 1st, the rules and regulations are going to be promulgated. So you've asked us to sign on to something now that we don't even know what the rules and regulations are going to be until July the 1st. So we're really at a loss of why we signed up or why we had to do it before it was finalized.
So I'm not exactly sure what you're referring to, but the racetrack safety rules that are effective July 1 have been approved by the FTC or in the Federal Register on our website. The two that we're still waiting for approval on, but we'll have, but expect to have by July 1, are the changes to the search and seizure rule, which we narrowed, and the registration rule. But the fact that you have the registration is required is in the act, and the law is effective whether or not people register. I mean, the registration process is to allow us to manage the program and communicate with people, but it's not a necessary predicate to the law being effective.
Okay. One of the main questions I have, and it concerns everybody, it's called the Horseracing Integrity and Safety Act. Why are the thoroughbred horses at the racetrack being singled out by this? Why is it not covering all of horse racing? I mean, you don't cover harness racing, they're excluded. Quarter horse racing is excluded. The breeding industry is excluded, even though they have 2-year-old and training sales. They have yearlings that they're prepping for sale to our clients. Why are they excluded from all this process?
So I hate to say that the only answer I can give to that question is that's the way Congress wrote the act. I mean, that's what the law says. As I'm sure you know, the other breeds can opt in. They can either opt in through a state racing commission, or they can opt in via an association that represents them. There are, some breeds that have indicated they might be interested in opting in. They're not opting at this stage, but the way Congress wrote the law, it was written for thoroughbreds. That's not really a question, unfortunately, I can answer.
Yeah, I noticed that they say when you nominate a horse for a stake race, that you become under this law. There's a lot of foals when they're born are nominated for the Breeders' Cup. That is a stake race. Why are they not being put under this law as a baby?
So you become a covered horse when you either participate in your first timed published workout, you participate in a covered horse race, which, as we know, is a thoroughbred horse race where the racetrack is exporting their signal for pari-mutuel wagering, or you register for a horse race. So what you're saying is, why aren't the Breeders' Cup? I'm not sure I understand the question.
In the definition, it actually says if a horse is nominated or has a timed workout,
right,
then they become a covered horse. So the Breeders' Cup is a covered horse race. The question has, and I've posed it before, that why are Breeders' Cup nominated individuals under the umbrella of a covered horse?
Why are they not, you mean?
If it states in the definition, there is a concern of why they're not included as being a covered horse.
I mean, my understanding of that is that it's been narrowly interpreted to, being registered to race in a covered, imminently in a covered horse race or after the first official published timed workout. But I can get back to you on that one, because I, to be honest, have not consulted with our attorneys on that.
The 2-year-old and training sales, those horses have recorded workouts, yet they're not covered under this scenario with the people that are responsible for them or putting them in the sales, because they may not be racetrack trainers or what have you. Well, are they not covered?
So my understanding is that they're not covered horses because those are not official public equibase workouts yet.
Well, another question I have for you is, I noticed that your budget for the 6 months of this year is a little over $14 million. What do you project it to be when you have to go for a whole year, especially when you have to start doing your testing and taking over testing?
So first of all, that's for 12 months, not for 6 months. It's for all of 2022. And second, the only way I can answer that question now, I guess, is a couple of ways. One is the Antidoping Medication Control Program. The arrangement that we reached with Drug Free Sport International will be a lot more cost-effective of a program than the one that was proposed by USADA, and that was a big factor in the consideration of essentially which agency to appoint. The other key element is that while in racetrack safety, we didn't have existing state budget monies allocated for various services that we could potentially tap into, that will exist for the anti-doping program. So for example, HISA will assume, laboratory costs, will assume legal costs, will assume testing costs. And the expectation and hope is that we will be able to negotiate and reach agreements with state racing commissions to apply some of those existing monies against essentially the assessment of the states. And I'm going to take this moment to announce that I'm happy to say that Mark Guilfoyle has joined the HISA team and is going to be helping us with that initiative. Okay.
It's always been in the past that the racetracks funded the testing programs. Mm-hmm. Is that going to change where the onus of it will be put on the owners now for testing?
So if you don't mind, I just want to step back maybe and talk about the funding model for a minute, because I didn't entirely agree with Eric's representation of how that works. So the way the funding model works is we have, the HISA budget gets approved by the HISA board, which you've identified the 14.7 number for 2022. And then what happens is that there's essentially a cost assessment methodology that determines, based on a weighted formula of number of starts and strength of purse, what each state's responsibility is for that budget, what their apportionment is. And then that number, if the state opts in, as Kentucky has, is covered by the State Racing Commission. And then I understand your point is probably that cost eventually trickles down to horsemen. I'm not familiar exactly with how that works. I only know about essentially the state assessment. In states where the State Racing Commission does not agree to opt in, the responsibility falls to the racetracks, who then have to negotiate with horsemen and other covered persons for a formula. So that's how the funding model works. Now, one thing that's important, I think, to communicate is that, I can promise you and assure you that one of the things that we're incredibly mindful of and are going to consider as we go through this process with the anti-doping program is to make sure that we're being cost efficient. And I'm optimistic that with a national program, we'll be able to realize some efficiencies. And then also, I recognize that the funding model that Congress gave us is a funding model that puts the responsibility on the industry. However you want to, Eric and I may disagree how to articulate that exactly, but I certainly acknowledge that the burden is on the industry as a whole. But what I'm hoping we will do is we will look for, and it's a commitment I will make and I've made before, that once we get launched and we get going, I am going to look for other funding opportunities outside of the industry to help bolster the industry and to help offset some of those costs. And part of why this is so important is that if we are successful with these national uniform guidelines and successful in improving our image with the public, I believe there will be other monies and opportunities available to us that will ultimately help ease the burden on the industry. I forget your question. I'm not sure I answered it, but I want to give that background. What was the specific question?
I really was asking, is the burden of the cost of this going to be put on the owners as they race horses, each race they race to be for the testing and all, or who's going to pay for that? Because in the past, they haven't been.
So the only way I can answer that is in states where the states opt in, it's up to the state to determine how that cost is assessed. Some states have had the money existing in their state budgets. I can't speak to what Kentucky's doing. When the responsibility goes to the racetracks have essentially done a 50-50 split between horsemen and racetrack. That's been the model.
Okay, so it's really left up to us to negotiate with the racetracks how this is going to be funded?
Only in states where the states have opted out of paying the assessment on their own.
Let me give an explanation. Most of you may not know the process, how it's gone, okay? The authorities sent out an invoice to every state. So every state that had a racetrack in it that was a thoroughbred facility got an invoice. The numbers have changed some, but initially there were 4 states that, as Ms. Lazarus said, opted in: Kentucky, Minnesota, Virginia, and California, and Colorado. So 5 commissions opted in. Now, they still haven't determined necessarily where the money's coming from, but they opted in, which basically says, okay, we, the commission, will figure out how to pay for it. The rest of those jurisdictions said, no, we are not. So then the authorities sent the invoices to the racetracks. Whether you had 5 racetracks in the state or you had 1 racetrack in the state, those invoices went to the racetrack. For instance, Oaklawn Park, we have some HBPA board members here. That invoice was sent to Oaklawn. They decided how it was going to be paid or if it was going to be paid. So that's the stage where we are right now. At this point, I'm understanding, at least as far as the first of the month, there are 9 jurisdictions that are either in or probably in. The rest of up to 25 in the United States, I don't count Puerto Rico per se, have not made a decision as of yet. The amount of the invoice is determined based off of a formula that the authorities come up with using the total number of purses or purse structure, and then it's formulated down to the number of starts at the racetrack.
Okay. What about the privacy of our information that we're giving you? When we register, we give you a lot of information. I understand there's not really a protective shield. What are you going to do with that information? And especially when the veterinarians start turning in records on animals that they're treating and all, who's going to have access to that information, and how are we going to know that it's being protected?
So first of all, we're absolutely subject to privacy protections, and we have a number of technical solutions that protect the privacy of all registrants. In terms of who's going to have access to the information is going to be available to the veterinarians on the racetrack safety committee in an anonymized fashion in order to conduct research and studies to help determine and improve, equine welfare and determine patterns and essentially trends that they believe can help assist and support improvements in equine welfare and reducing breakdown rates going forward. The only other availability of those records will be when there's a claim and the records move from the original owner or from the original trainer or owner to the claiming trainer or owner. But otherwise, nobody else will have access to those records.
Okay. One thing that really concerns me, and I want you to explain to me, what about the states that don't sign up for this? They refuse to be part of it. Is there going to be any backlash to them? Are they going to be able to simulcast out? Are they going to be able to simulcast in? Or how are we going to treat states that don't sign up? And if you can't get everybody signed up, why get one signed up?
So let me first just start by dispelling the notion that signing up really matters. It's a federal law, so it applies to every jurisdiction that conducts thoroughbred races is subject to the law. That's the full stop. The way it's going to actually work in practice is that there are a number of states, and I think it's more than 9, but we'll know by the end of the month, a number of states that have agreed to work with us including Kentucky, to voluntarily implement the federal law. And the reason those agreements are important is that they help to minimize costs and maximize efficiencies. So to be honest, there aren't that many rules, particularly in Kentucky, that are particularly different starting July 1. So what it allows the state steward or the association steward to essentially implement the additional HISA rules at really no cost or very minimal cost to the state or racetrack. If a state refuses to do so and doesn't want to enter into the agreement, we end up with 2 choices. One is we can work with the racetracks directly, and that's proving fruitful in some jurisdictions. If the racetracks don't want to work with us, then the way that Congress wrote the act is under the U.S. Commerce Clause, which is the constitutional link. we is the way that Congress regulates, is able to regulate interstate wagering. Essentially, those racetracks will face losing their right to export their signal for pari-mutuel wagering.
But they will be able to import?
Yes, they can import and they can do anything intrastate.
Okay.
Yeah.
They just can't send their signals out.
Correct.
And okay. I want to talk a little bit about medications that are going to take place come the January 1, I think it's when that is implemented. Mm-hmm. I read where trainers are guilty before they have a chance of a due process to prove themselves innocent on a therapeutic overage on a test or whatever. A test comes back cloudy or bad, and they say that the trainer and the horse will be suspended until a hearing comes up. Usually it goes just the opposite. We have a hearing.
That's incorrect.
That's a what?
That's incorrect. That is not correct. So that representation is not correct. That is only, so the way that the anti-doping rules work is the new version that's been posted on the website. And I spent a large part of my career running an international equine anti-doping program. So this is one area where I have a lot of comfort and expertise. So essentially the equine anti-doping rules, which are currently proposed, divide substances into two categories. One is banned substances, which are doping substances that should never be in a horse, theoretically. And then the others is therapeutics. For doping substances, there's a provisional suspension imposed, and the trainer has a right for an immediate hearing to ask to lift that suspension, but there is a suspension imposed the minute the sample comes back positive. On therapeutics, there's no suspension until there is the due process. And actually, in fact, under the proposal that's currently, as I said, up for public comment, for the very first medication overage, the trainer can opt for the administrative procedure, which is to admit the violation and pay a fine with no suspension. Okay.
What about moving the vet rule from a 7-day vet list to a 14-day vet list? If you've not been familiar with horses being put on a vet list, 14 days, well, then they have to do certain things to get off the vet list to work, and then they have to draw blood and send the blood off, which is another 10 days if you're lucky to get it back, maybe even longer. So in essence, a horse could have a problem one day that could be over in a couple of days, but he's really missing 30 days almost of half of a meet here at Churchill Downs, which is a 58-day meet here in the spring or so.
So that I believe you're referring to the racetrack safety rules on the vets list. And all I can say to that is that's, I'm not a veterinarian, and that's the rule that the veterinarians on the racetrack safety committee and other veterinarians, including some from Kentucky, determined was the right rule for the program.
Yeah, we have a 7-day rule now, and my medical director told me it was going to 14.
Both. Yeah.
Okay. Eric, you want to ask her a few questions that you had, and then let's open it up to the floor and let's give these guys a chance to speak.
Thank you. Thanks, Rick. So, Ms. Lazarus, I believe if I correctly interpreted what you said, I think we all know that the safety regulations have been approved by the FTC, along with the methodology and the enforcement program. But it is a correct statement to say that the registration rule has not been approved by the FTC.
Yes, it's correct to say that the registration rule is pending, and we're expecting it to be improved, imminently. The only kind of clarification I'll say is that the Act requires us to have a registration rule, and so we had to have a registration rule up and running on the timeline that we did, and so we have basically launched the registration rule that we have, and we expect that it will be formally approved, very soon, prior to July 1.
Great. And July 1, as everybody probably knows, but just the correct terminology is the program effective date. That's the date that was put into the Act itself, July 1st, 2022. So a lot of folks, including myself, Ms. Lazarus, have really tried to encourage a delay in the implementation. I know when you and I spoke not long after you first got started, we asked if there would be an appetite for that. What is your position now, having gone through a few months of the process?
What I'll say to that is the timelines are certainly very aggressive, and no one's feeling that more than those of us at HISA who are working basically 20-hour days around the clock to do the best that we can to make this as smooth as possible come July 1. A delay is outside my authority, and there has been no interest or appetite for a delay from Congress or from the FTC.
So if I heard you correctly, you said a delay is outside your authority. So then who authorized the delay in the anti-doping and medication control program, along with the other two rules that are in the safety regulations that have already been approved?
So for the anti-doping medication control program, that was the FTC.
Can we see that documentation?
I mean, right now, I can certainly come back to you on that. And the second is on the, I think you're talking about the delayed implementation of the specs for the crop and for the horseshoe. And that's an internal HISA decision to delay enforcement, not to delay the rule itself, but to essentially communicate that we're not going to sanction, or there's not going to be any negative consequences for anyone who doesn't have those by July 1, just given the supply chain issues, et cetera. That's different from being authorized to delay the entire program and the effectiveness of HISA. What we've tried to do, and I realize, it's a no good deed goes unpunished kind of theory, that what we've tried to do, honestly, is in those areas where we could make transition smoother and make it more attainable and easier and less complicated for racing participants, we've done that. And so that's why we delayed those two areas, but it's an enforcement delay. It's not a delay of the rule.
So I'm just going to say that I respectfully disagree at this point. I've spent a lot of time dealing with federal representatives on this issue, and I have several that have questioned how and when was the portion postponed. That's why I asked for documentation, because I personally, including some Kentucky delegates, have not spoken to any representative that had that proof. I'm willing to see that proof, but can we continue to get the feedback of Congress gave us this date, July 1st is the program effective date, and we're doing everything we can to be up and running? Well, there's been delays. So how did those delays occur? Because I think if you look at this from an industry perspective, right now, a delay makes a lot of sense. Whether you agree with HISA or you don't agree with HISA, everyone agrees on national uniformity. The HBPA has been campaigning for that a lot longer than I've been around. We all want it, but we also want to do it right. And we definitely want the due process to be addressed. My point is, if there has been a delay, it appears by all means that I can see the authority made that decision. Okay, then let's talk about, and we have certain representatives in Congress that are understanding maybe that's a possibility. It would help everybody in this room. Something as simple as the registration has not gone well. And there's a lot of questions. There's a lot of tweaks that maybe need to be made. That'll give them time too. Ms. Lazarus said it in the Blood Horse interview. I wish I had more time. I can't tell you how many times I've heard Ann McGovern say, I wish we had more time. John Roach said, this is an insane timeline. We've got letters trying to get people to understand a delay would help a lot of things, whether it be the establishment of the rule or the tweaking of the issues that they have. I think it should be a consideration, and we would respectfully ask Ms. Lazarus to continue to have that option on the table with your authority.
So I can just say a couple things, maybe just to clarify. So one is with respect to the anti-doping medication control program, the Act specifically says that we are not allowed to present rules for public comment until we've appointed an enforcement agency. So what happened is prior to me becoming CEO in February, and just so everyone knows, I've been in this job for 4 months, is that the negotiations between HISA and USADA did not result in an agreement. So we had to restart that process in early 2022, which ultimately led to the agreement with the Center for Drug-Free Sport. So because of that timeline, the act actually prevented us from promulgating rules and launching the anti-doping medication control program in July. I actually think that it's a benefit to everyone that, even though I didn't engineer it, that the programs are being launched one by one. So it gives the industry time to adapt to the racetrack safety program before they have to adapt to new rules for doping medication control. I think that's actually going to be a benefit. It's going to allow us to sort of develop our relationships with the state racing commissions and with the racetracks. And I think it's, obviously if a delay is being requested, this phasing in, I think can only be better than everything at the same time. In terms of wanting an extension, I can only say that I disagree with you. The authority has the right to extend the program effective date. It's very different from us taking the position that enforcement will be phased or delayed. What I mean by enforcement is that you'll be told by a HISA official or in a state in Kentucky where we have an implementation agreement, that's not a compliant whip, or those aren't compliant horseshoes, but there's no consequence. We're just letting you know so that when ultimately there is an enforcement mechanism in place, you know what the rules are. And our philosophy is going to not be punitive. It's going to be educational. And I think what you'll see come July 1 is that no one's going to be playing gotcha. We're just going to be trying to explain the new rules, bring everyone along, and hopefully ultimately, have it be a lot smoother than I guess Eric anticipates. But ultimately, I just have to disagree that from a technical standpoint, I do not have the right to tell Congress that the effective date of HISA should be moved.
Rules with no consequence. That's an interesting one. I'm going to ask one more question, and then we'll open up the floor. I think Julio and Bill have the mics. This is a question that I briefed a little bit at the American Horse Council, but just so everybody understands, this is Eric's interpretation of the the Anti-Doping and Medication Control Program, which is the 3000 series. That is up on the HISA website. You have every right, and I certainly encourage you all to try to make comments. It's a very technical document. It takes a while to get through. The understanding that I have, and I'm going to paraphrase a little bit, the presence of any, they've changed the term here a little bit, controlled medication, which is now substituting for therapeutic medications. What we see, or at least what I interpret, is any controlled medication presence will result in a violation. My interpretation of that is limit of detection, zero tolerance, no thresholds are going to be utilized. Now, in fairness, I asked Ms. Lazarus this at the American Horse Council. We talked a bit about the laboratory uniformity, which I will stand on a soapbox and say all day long. I have campaigned for laboratory uniformity for many years. That's the biggest problem that I feel our industry has. And that's what the answer came back as. But from a simple statement, if you can explain tell me that I'm wrong.
You are wrong.
Interpretation.
You are wrong. And part of the answer, in fairness to Eric, is that there is another document that we're preparing that has not yet been posted. It's going to.
So I'm not wrong in what I'm reading. I'm wrong because I haven't seen the internal document.
Well, no, I mean, I guess I'm gonna meet you in the middle and say we're both a little bit wrong. So you're right in that there is still a document that is forthcoming that is going to give more information around thresholds, limits detection, et cetera. The other piece of it is that is also set at the laboratory level. There's no such thing as zero tolerance. Like there's no, without getting technical, there's no intention of calling therapeutics at a limit below where they're effective as positives. That's not we're not interested in that. That's not what we're trying to do. We're trying to make a fair system and a system that protects horses and people. So that's absolutely not the way it's going to work. There will be more information forthcoming about those limits, and it also will be something that's addressed at the laboratory level. But I'll also compliment Eric and say that after you asked that question at the American Horse Council, I did go back and look at it more carefully and realize that we were missing some information. So you were doing your job.
What we're really concerned with is contamination in our society. Drugs are so prevalent everywhere you go. I received an email yesterday from Dr. Tobin, which is one of the best that I think you can get that works for UK, about a dog that urinated in a stall, and the dog was on Gabby Puiton, and a couple of the horses that were racing from that venue came up positive from that, and they've determined that it was because the dog urinated in the stall. What I'm saying to you is, when you put in these checks and balances, you've got to take into effect of there's people working on a backstretch that are on medication. And if you don't have everybody listed on every medication they're on, it's very conceivable that a trainer could come up with a positive just because of the testing is so finite now that these computers can pick up a speck of dust. And I will make a statement that Dr. Barker from Louisiana State made to me one time. He said, the problem we're having is that the testing has far out exceeded the intent of the law, because the law was to catch somebody doing something wrong, and that's not true with the computer.
So first of all, I know Dr. Tobin and Dr. Barker very well. And second of all, I'll tell you that there's no one who's defended more horsemen and contamination cases in sport horses than me. So there's a provision in the rules, which was something that I insisted on having, that addresses contamination. First, there's a new category called specified substances, which means that any substance that, if used intentionally, might have an unfair impact on a horse, but is more likely to be a contaminant, has a special procedure. So there are certain things that have shown up in feed, et cetera, that have been problems over the years for horses. So those are treated differently, and you have an opportunity to basically demonstrate and show how, that it was in fact contamination, and there's not a presumptive suspension if you fall into that category. So, and you can get, and you, as long as you can show the contamination, you can get zero fault, and it's as if you never had the charge. So that is a very important question and a very important area. But it is something that we address in the rules, in the new version.
I appreciate you defending these so you'll understand them more. One other thing, and this is the last thing I want to ask you about. We've been told that for 48 hours before a race, you're not allowed to give a horse any supplements in his feed. That included vitamins or any kind of supplements as they may be on that has no pharmacological effect on racing. They don't want us using Magnum Wave blankets for muscle soreness, or they didn't want any icing of any joints. Is that going to be the case?
So the regulatory vet in Kentucky is the one that will be allowed to make policy about that, including Lasix and everything. So they'll be allowed to determine what's allowed within that 48 hours. That will be regulated on the state level.
So that there's a possibility that could happen.
That they could allow it, yes.
Okay. So we need to work with our state vets to get that done,
yeah.
Okay? Now, what I'd like to do is I'd like to open the floor up to anybody that's got a question that concerns you. If you just raise your hand, we'll bring the mic to you. And please keep us respectful. And we're thankful that Ms. Lazarus showed up here to answer some of these questions for us, because this is going to be an undertaking that I'm afraid it's going to be a little harder for us to implement than they think it's going to be. So anybody got a question? Neil?
Sure.
Sir. Okay. First question is continuing education. Grooms and owners, why do they need continuing education?
Ooh, that's a hard one. No, that's a determination that the Racetrack Safety Committee made, because they believe that everybody could keep learning and everybody should have some stake in how their horses are being treated, et cetera.
Okay.
And I believe it's only 2 hours a year.
I know, but what are the grooms going to learn?
You're asking me, what are the grooms going to learn?
Yes. I mean, some of the grooms can't read, can't write. I mean, you know, they're there to clean the stalls and groom the horses.
Okay.
And 2 hours of continuing education for them is harder than you think.
Okay. Well, I will address that. That's a fair point.
And One of the outriders asked me this. They're supposed to get 2 hours of continuing education, which is fine, but it says at each meet. So there's 3 meets here at Churchill.
Yeah.
Do they have to get 2 hours for each meet?
No, we're going to provide guidance on that. That was an error, and I apologize for that. It should be, when they drafted the regulations, they were thinking that each meet was annual, but we realized that creates a problem. So it's an annual requirement, and we'll be issuing a guidance on that point.
Okay, and that'll cross state lines.
Yeah, cross everything.
Okay.
That's what HISA does. Cross the state lines.
On the Magna Wave, in the rules, it says 48 hours before a training or race.
Mm-hmm.
So does that mean we can't use that for during the week while we're just training them?
If it's so a training is any activity at high speed that's timed.
So a work.
Yes.
So you can't use it 48 hours for a work
unless
or a race.
your state vet says that those procedures are okay.
Okay.
Yeah.
Because it was a little confusing. But in other words, we could throw a
that.
Magna Wave out because we're going to be training every day.
Yeah.
And on the jockeys, on the whipping thing,
Mm-hmm.
the class 2 and the class 3 is loss of purse, and the jock gets fined
Mm-hmm.
500 or 750 plus 20 and 30%.
Mm-hmm.
Well, if they lose the purse, there's not going to be 20 or 30%. So I don't know why that's in there.
Right.
And why would the owner suffer from a jockey's mistake like that? It's because it's not interfering with another horse, but because the jock can't count to 6,
Right.
he's going to lose, say, a stake race, 300,000 plus the value of the horse could be $1 million.
So this is something that the Racetrack Safety Committee debated for a long period of time. And my understanding of what they've explained to me is they were concerned and were aware of situations where owners were essentially telling, maybe not in Kentucky, but telling the jockeys, whip as much as you want and don't worry, we'll pay the fine. And the crop rule, in terms of public sentiment about the crop, it's really difficult for us to manage. And I know it's not something that is necessarily understandable in this room, but it is something that we really deal with all the time. And, you know, you've got a number of states where there was no crop, like in California and New Jersey at all. And those states are really unhappy that we've gone, in their view, backwards. And there was a lot of sentiment about actually eliminating the crop entirely. But this is where the Racetrack Safety Committee landed.
Okay. It just seems very unfair to me for the owner, because you could be talking millions of dollars in stake races on value of the horse and the purse together.
Yeah, I do understand that. And you're not the first one to make that point.
Let's keep it down to 1 or 2 questions.
Okay. Let me just say one more thing then.
Sure.
To enhance the safety of horses was one of your goals.
Absolutely.
Is there any way to stop surgeries on these foals, correcting them, putting screws and bolts in them and changing the conformation? Because that has more to do with the breakdowns we have nowadays than a shot of Lasix does.
So that is not something within our authority now, but it is a really good point and good issue to raise. And it's something that we will look into. You're not the first one to raise it. Yeah.
Okay. Anybody else got a question? The lady in the back, Bill. Just a minute. Just please let us get the microphone to you. Julio. Okay, next.
Okay.
Is that the trainer still considered the responsible party? I'm good.
Yeah, the trainer. So the way the system and the program is built, that there always has to be a responsible person for every horse. So if the horse goes, it still it's still in training or with that trainer, and it goes to a lay facility, it's still the responsibility of that trainer. The trainer can give the horse back to the owner through the system, but there always has to be one responsible person for the horse.
But the trainer doesn't pay for the help or the covered employees that are at the layup facility. So therefore they don't see the horse day to day. They've been sent to another farm, or they've been fired, and maybe they won't get the horse back.
Right. So in that situation, the trainer, if they have concerns, should give the horse back to the owner, which is easy to do in the system.
So you just change it in the system to the owner. But as the system is right now, even though we have all of our horses registered and several of our owners are registered, the trainer is still listed as the owner. That's a big problem.
As the responsible person, but you can
no, as the owner.
So does that mean because they register as the owner?
No, they did not.
Is it, do we have Steve on the line? He was supposed to be on Zoom somewhere. Yeah, so normally that's exactly, yeah. So if the trainer registers before the owner, my understanding is that the system defaults to the trainer being the owner.
That's not, I mean, that's something that you need to fix because that's not how it is right now. We're currently the owner for all of our
but they have to accept it. I think the biggest issue that we've seen in this instance, I think that point is very valid and it is a glitch. The other part that we have tried to work through is an understanding that if a trainer in Pennsylvania, if an owner in Pennsylvania who's the responsible person wants to give it to Lisa? Brad Cox, then he's got to accept it. And I think that's not at least clearly defined. I haven't registered, so I don't want to say it's not in there, but I don't think it's very clear because that has been a problem. There has to be an acceptance.
So, hi, Lisa. Sorry about that. I couldn't unmute.
Okay.
So I was trying to get in there.
If we can let Steve address this, that would be great because this is
sure.
a little bit outside my.
When you register the horse,
Steve is our chief technology officer, and if I can just get the name of the woman in the back so we can fix her problem, that would be helpful as well.
Oh, yeah. So when you register
Steve.
Am I good? Can I talk yet? Can you guys hear me? I'm unmuted. Can you guys hear me? Hello, testing.
Technical difficulty.
Testing. 1, 2.
Okay.
Can you guys hear me?
I don't think that's going to get it.
Hello. Hello.
Go ahead.
Hi, can you hear me?
No.
I can hear you.
Zoom callers can hear me, but the people in the room can't.
Okay, I think that's not going to work. So what we'll do is we will come back to you on that.
Let me ask you one question. How do you propose to monitor every horse, every trainer on every racetrack and every farm in the United States? Well, I mean, you're putting all these rules in for things.
So we don't
goes to the farm. I mean,
no, we don't. So no, we don't have authority over farms. We only regulate at racetracks and official facilities. Now, if a covered horse goes to a farm and is given something prohibited, whatever, that's still within our rules. But we're not, going and checking up on farms.
You're not going to the farm and actually monitor the horses because we've been told they can't be freeze-fired or blistered or anything for layups or whatever the traditional methods have been.
That's a different question.
Yeah.
Correct.
Okay. Claire, you were next.
To begin. Dr. Claire Finger, I'm scientific. Hi, Lisa.
Hi, how are you?
I'm a scientific and veterinary advisor to the HBPA and the
great.
USTA and the North American Association of Racetrack Veterinarians. So
great.
So my first question is, because I think we're both very familiar with synephrine.
Yes, exactly.
And so that's on the banned list in your specified substances.
Mm-hmm.
What does that mean?
So what it means is that if a horse tests positive for synephrine, there's no automatic suspension like what happened normally with a doping substance that's not specified because of the recognition that there's a high potential for contamination. And then ultimately, the responsible person needs to explain what happened, needs to help investigate, how the synephrine came into the horse's system. And then ultimately, so long as contamination is the more likely scenario than not, there'll be no fault and as if there was no violation.
So in the regulations, it states that we have to demonstrate where it came from. Mm-hmm. That's not always possible in the case of environmental substances. For example, a lot of times we get the positive test 3 or 4 weeks later, and the feed that we were using is long gone. We have a series of cases and if you want to know about positive cases and what we've seen in this country, mm-hmm. myself, Dr. Tobin, and Dr. Barker are the ones to talk to. Mm-hmm. We had a series, this was in Standardbreds, but this was at Hoosier Park, where a trainer had multiple CBD positives, and she assumed it was coming from one of her grooms was using a CBD cream. So interestingly, they had the CBD cream tested, and guess what? There was no actual CBD in it. So
that's a different issue.
Buyer beware. But point being, that was clearly not the source of all the CBDs. She was disqualified for weeks. And for Standardbreds, they race once a week. So that was a big deal. Finally, out of frustration, she just moved out of the barn at Hoosier Park and started shipping in from a farm to race, and no more CBD positives. So in that case, other than the barn was clearly, something in the barn was clearly the source. She couldn't come up with, we couldn't demonstrate, we, the forensic investigators, of which I am one, and you know several of the others, Kimberly Brewer, Tom Tobin, we could not come up with a source. That's part of what we do when we get hired on these cases, is try to figure out where it came from. There was a series of CBD positives in Nebraska. We have pictures. We went to the hay fields, and in the rows between the fields were wild hemp. Mm-hmm. And so there, at least we could identify it, but the trainers have no source other than to say, don't buy your hay from Nebraska, because Nebraska's state #1 for feral hemp. These are clearly levels that are well below any possibility of an effect. Yeah. Same thing with the synephrine and teff hay. Teff hay is becoming more commonly used because it's drought resistant and there's a lot of nutritional benefits to it. Mm-hmm. So,
Doc, we're trying to limit the questions, not stories. And so let us go to Dale back here, please.
All right, Lisa, thanks for coming. First of all, everybody here has a lot of concerns, and we can stay here all day going concern by concern by concern. But the best thing I learned today is that we got a hard date of July 1st for a slow rollout. Mm-hmm. Penalty phase does not kick in till later. Could you all commit to coming back to a certain little group of horsemen before the penalty phase kicks in and go line item by line item by line item? You can't do it in a huge room like this for the concerns and the studies and what you've learned between the slow rollout and the penalty phase and the hard date where everything really kicks into effect.
Sure. So just one clarification. It is, the penalty phase does kick in, from the beginning on the crop roll. I mean, just so that's clear. The stewards in Kentucky are, first of all, I think Kentucky is best positioned for that because the crop rule, at least with regards to the 6 strikes, et cetera, is most similar to Kentucky than any other national crop rule. So I think, there won't be there are many states where there's no limit at all on strikes, where the kind of learning curve is going to be a lot more difficult. But yes, other than that, I will absolutely commit to coming back. And the other thing I'd like to say is I think it'd be really helpful to have this conversation, maybe more than one, ahead of the anti-doping medication control program coming into effect. Because as Eric said, now those rules are still up for public comment. We're still taking in information. They're not final. And we're going to have a chance to really, talk about them, educate, et cetera, and get ready. So
I would say, I think the crop rule is one of the least concerns that we have. The penalty part of the crop rule is a problem.
Yeah.
I don't think if he robs a bank because he's working for me, I go to jail.
Yeah.
And that could all be worked out later too. We could review that at one point. But the other rules are the biggest concerns that are going to put our livelihoods and our careers in jeopardy.
Is there a specific rule that you're concerned about?
There's several, but there's too many to go. Like I said, there's too many to sit here all day and go through line item by line item by line item now with all the people here. Everybody has a question to have. Okay. But at some point, before we go into the hard rule, I'd like that commitment that you come back and go line item and line item with some of us in a horseman's group, somebody around the nations, pick a few from every horseman's group, and we will cover concerns over a whole day period or whatever it takes.
I'd be happy to do that.
Thanks.
So before we get to the next question, I do want to clarify something. Rick talked about an issue that's been going around a lot. And again, I would say a misnomer about open entry to a farm, carte blanche. Okay. I think everybody should know that when you get a license in the state, there's a lot of that same wording in there. Now there's some other parts to the registration that I think are concerning, but in that exchange, Ms. Lazarus brought up something that I know is a big concern for a lot of people. Pin firing and freeze firing, and how that's going to be, let's say, penalized, or what exactly is going to happen. Rick kind of intermingled it in a horse shipping over to a training center and gets pin fired. That is no longer something you can do. Do you want to explain that?
Yeah, I mean, I have never talked so much about pin firing in my life. So I recognize that it is a concern. It is a change for some people. The issue was, again, the veterinarians, many racetrack veterinarians, some non-racetrack veterinarians, and in addition, the American Association for Equine Practitioners have all made the determination that pin firing, should not be permitted given the horse welfare issues that it raises. I am really not qualified to debate whether or not that's a good decision or a bad decision, but it's a decision that's being made and it's a rule that we have. In terms of, pin firing prior to the effective date, we've just asked simply that you keep a record, keep a photo, keep anything you have. As I said, the rollout of this program is not going to be an I gotcha situation. It's really going to be, reasonableness and governed by, trusting, all of you, that if you share and you say that this pin firing took place ahead of time, and you can share a photo or share some documentation, that's going to be believed. In terms of, enforcement, ultimately it's going to be up to the regulatory veterinarian to make the decision on what the consequences are. It could be that the horse can't race for a period of time, that it goes on a vet's list. But ultimately, there's, and the pin firing rule is limited to, freeze firing and thermocautery, which I guess is the burning or the freezing of the horse's fore and hind limbs. Yeah, and blistering. I think that's allowed. I think that's allowed. But let me get back to you on that. Again, I'm sorry. This might, yeah.
Yeah, I think that's a big concern. Is we've heard trust, we've heard intent of the rule. We're not going to, but the black and white is the black and white, and that's a concern. Again, it states blistering. We have some time to comment. I don't know that anybody in here has commented yet. If you've got something, you can try to send them to me. We'll try to get them in. But the black and white is the black and white. And at the end of the day, trust me, and it's not intended to, or it is intended to, doesn't fly with most of us.
No, I'm sorry. And let me just also, what I was talking about with regards to the trust is for those horsemen who pin fired prior to July 1. If you're approached and asked about the pin firing by the regulatory veterinarian or association veterinarian, to be able to document or show that it happened prior to the effective date, it's obviously not punishable or not within our authority. Anything before July 1, we obviously don't regulate. So I was really just referring to the documentation or representation that the pin firing happened prior to July 1. I mean, I would imagine that if it was 2 years ago, the veterinarian could easily see it's not recent. But if you have any concerns, just take a photo.
Any other questions? Somebody? Jason, can you get a microphone?
So with the training records that are expected to be turned over, when a claim happens, what does that entail? Like, I've seen supplements are required to be turned over. In the one Zoom meeting, they said, take a picture of your whiteboard and turn that over. So what exactly is going to be needed? Just the medications that you give that are prescribed by the vet, or all the way down to the electrolytes that you give every day?
So one thing I want to say is we've moved away from the whiteboard concept. And I want to make clear that we've gotten a lot of feedback from trainers. We've listened to trainers who have said, I don't want to turn over my training regimen, kind of my unique program elements. And we listened to that and we fully agree. So no training records are required. And I apologize for the whiteboard comment, but this is a work in progress. So on the medical records, you need to share veterinary records, any surgeries, obviously any procedures, And and beyond that, it's just then becomes voluntary, what we think would be helpful for the new claiming trainer or owner to know. What's required is the veterinary records. Yes, you do. You have to turn over all of the any recorded treatments, any veterinary treatments, any surgical procedures, et cetera. Yeah.
Question. This whole thing's for uniformity for everybody in the United States, but you just sit there and said that the state vet 48 hours out can tell us what we can and cannot do to our horse before it races. So if it's in Kentucky, they're going to say one thing. Indiana, they say something else. And somewhere else, they say, now, how is that uniformity?
No, that's really just for the administration of Lasix and those pre-race.
No. We was talking about ice on our horses.
Right.
What can we give them? What supplements we can give them 48 hours out? And you're saying our state vet determines that. Well, Kentucky's going to be different.
No,
Indiana, and everybody. Now, how is that any kind of uniformity?
No, there will be uniformity. I need to clarify that also.
Where is it at?
Yeah.
Where's it at?
Yeah. It's a good point. I need to clarify that point.
When you leave this to the state vets.
Yeah, no, you're right. I mean, that's really for the Lasix, and I need to clarify what else falls in that category. Sure.
Me next? Yeah. I have a lot of my questions. I've got a list here, but most of them have been covered. But in the shoeing department, I will say that I'm about 7 or 8 years ahead of you guys. I haven't used anything but Queen's plates for that long. But in the regulation, it strictly states in every clause, full rim shoes. Now, does that disallow 3/4 shoes?
So the regulation says the 2 millimeters are allowed.
That's the toe grab.
Right. No, that's what I'm talking about.
I'm talking about it says directly full rim shoes. Okay. Do you even know what I'm speaking of?
I know what you're speaking of, but I don't have an answer to your question. I'm going to need to ask the vet, our head vet about that. And I will.
Okay.
Yeah. No, I know what they are, but I don't know the answer.
If you can't 3/4 a shoe, we have small. I mean, this is what is so disturbing about this. We're battling. We used to have to worry about if we had a good date to get in races. Now we're talking about worried if a race goes. We're dealing with 5 and 6 horse fields, and the additional rules and regulations that you guys are setting forth here are going to do nothing but drop the population of the horses that are available to race. Now, I have felt for years that the Jockey Club has wanted a European model of racing, and they don't want common guys like me in the business. But the continuation of this stuff is going to create an elite racing, a small number of racetracks, and only the aristocrats and the very wealthy people are going to be involved in this game. And maybe that's what they want. I don't know. But I can tell you where this business and this industry is headed, and it's not a good thing. It is not a good thing for racing. Thank you.
I mean, I can only say that that's definitely not our intention. I understand, your sentiments, and you certainly can have the right to feel them, and we'll have to see in another year or so.
Go
ahead.
My question is about the proposed anti-doping rules in terms of non-steroidal, so anti-inflammatories. I've been instructed by my veterinarian that some of the rules propose 0 anti-inflammatory 7 days prior to work or race. And some of these rules are still up for negotiation. Should we go through our practicing veterinarian, or does our practicing veterinarian have to go to the AAP? Who are you taking?
We're taking comments from everyone and anyone. And the email address is, ADMC feedback@HISAUS.org. Or you can also ADMC for anti-doping medication control feedback as one word at HISAUS.org. You're also welcome to get a card from me at the conclusion of the meeting. You can also email me directly or have your attending veterinarian email me directly.
Okay, and a follow-up question. What about, you know, a big issue, and this put us in a public light as of late, is obviously the federal case against, you know, Jason Service and Jose Navarro. What emphasis are you guys going to have on these synthetic EPOs that we cannot test for? Is your testing center going to be more adapted to, you know, finding these?
So there's two components. So first of all, as you know, we're in the process of building the anti-doping medication control program now, and there's a big emphasis on investigations and doing intelligence-based testing and not just random testing, so that ultimately, you know, you're looking through the investigative phase for potential issues and problems, so you can be more intelligent about figuring out where the violations are coming from. We're also working with the labs to ensure that they can, you know, find whatever is out there. I mean, that's always the challenge, right? Is the lab sort of keeping up with the science? But we're going to have, you know, more intense accreditation procedures for labs with an emphasis on being able to essentially locate and find those substances.
Right. So are you saying there's going to be more emphasis on wiretaps versus testing, or more?
Well, we're not the federal government, so I'm not allowed to issue. I shouldn't say sadly and be so glib. We don't have the authority to order a wiretap because we're a private entity. We're not the federal government. But no, what I'm saying is that there are investigative techniques and research, et cetera, that governing bodies all over the world use to protect their industries, their sports against integrity violations. And we'll be using those sort of state-of-the-art techniques that are available to private entities to be as effective as we can.
Chris, I'm speaking for Will, but Dr. Farmer is reaching out to your practicing veterinarians to go through questions like that. So lean on Will and make sure that you give to him some of your feedback, because he can run that up as well through your vets.
And so one other thing I just would like to say about the ADMC program, just that I think would be helpful, is there was one version of the program that was up for public comment when USADA was still still negotiating with HISA to be the enforcement agency. The new rules take a different philosophical approach, and what they do is they create a clear division between doping substances and therapeutics, and they treat the doping substances a lot more harshly, and the therapeutics with firm consequences, but with much more pragmatics and understanding that those are substances that are used in horses. They're just not allowed on race day. So there is a clear division, which I think, you know, is something that I would expect horsemen to embrace and find to be better than lumping it all together into one program. Everyone starts with a clean slate.
Go ahead.
Yes, just the comments and studying what's been going on this morning. This is the take from a small owner breeder here in the state of Kentucky. It's just like what our country was founded on: taxation without representation. Us as horsemen, we have no real input on any part of this law or the law enforcement. My question is, why has the horseman herself not been more integrated into the procedures going on till now? And why are we not, at least from our standpoint, having all of our problems looked at on our local level more than on federal level?
So I'll answer the part that I think I can, and maybe Eric wants to contribute also. So the first thing I'll say is the horsemen are really important, and I am showing up and talking to every horsemen's group that wants to speak with me. And we've made changes in response to horsemen's concerns and issues that horsemen have identified. Congress passed the law. I mean, there's not much more I can say than that, other than my job is implemented, and I took this job long after Congress passed the law. What I can only tell you and commit to you is that I am listening, I am responding, and I will. I can't always guarantee you that your concern or your opinion will be implemented, but I can assure you will be listened to, and I can point to the record that's been in place since I took over of making changes based on horsemen's comments. So, all I can say also is that I genuinely apologize if you feel that you've not been, consulted enough, or there hasn't been a voice.
Makes you kind of feel like you know what the Boston Tea Party was all about, No, only other question I had,
sure.
Why can we not at least have a say in the enforcement procedures? I know you have not got your board set up for that yet. Why cannot the horsemen be involved on that board?
You mean for the Horseracing Integrity and Welfare Unit?
Yes.
Okay, we don't have an official board. We have an advisory council. And that is something I will consider.
There's nobody more adept than the people involved with it every day to know what the problems come from, where they come from.
Fairness enough.
Yeah.
Sorry?
Who appoints the council?
So the council is an advisory council, and it was appointed by really the Center for Drug-Free Sport, because the way that the act works is that we appoint the agency, and then the agency has the independence to create the advisory council and essentially hire the staff that's going to run the agency. But they certainly, I think, would take feedback on that, and would be.
One thing, Lisa, I think he's trying to say, and I agree with him. Yeah. There should have been a input from a trainer, jockey, and veterinarian community into these things going in, and there really wasn't. This bill, we feel on its own, would have never passed through Congress if it hadn't been stuck into that COVID relief bill, because it was at bay for 3 or 4 years, and it got nowhere until they slid it into that COVID relief bill, and then it went right through. So we feel kind of taken aback by that, because we never got a chance to debate it at all.
Yeah. I will say that on the Racetrack Safety Committee, we do have, Johnny Velasquez was very involved in the rules and in their development. So there was a jockey on the Racetrack Safety Committee, and there has been input from trainers, but I acknowledge that there hasn't been the formal.
Okay. We got a question in the back. Sure. I want to say, but also I want to get a question from you veterinarians, because you guys are going to be required to do a lot of things that's going to be out of the normal. So let's take that question, and I'm going to get to the vets.
I am a vet. But I wanted to ask if the thresholds were changing for the therapeutic drugs.
So the thresholds, I don't think for Kentucky will change very much, just based on what I know of your system, but that is the document that is forthcoming, and that will be made public very soon for comment.
I think that might be a little bit misleading, because everything is 48 hours now. Everything is 48 hours. So based off of what the threshold is based off the research, where the threshold is set now. So, but again, fair question. Please continue, Doc.
Because is there any research being done to give us appropriate withdrawals if the thresholds do change?
So everything is research based. There's a number of sources we can draw from internationally. There's the International Federation of Horse Racing Authorities. There's also the International Equestrian Federation. So all of that research is being looked at, and any thresholds will be research based.
And y'all are going to let us know what
the
appropriate withdrawals will be.
Yes, we will for the main substances.
We have some really good questions coming in on Zoom.
Oh, sure.
That we can't hear. So Jenny
okay, great. Sure. Thank you.
Give me the microphone again, please.
Julio, if you would, there's a question over here in the back row again. We'll get through some of the Zoom questions. Somebody had their hand up. Let's get through some of the Zoom questions over here.
Starter Steve Keach did send this in as an answer to the question back there. The person who registers the horse becomes a responsible person. The person registering the horse can set the designated owner when registering the horse. If the designated owner is not entered when registering the horse, then the person registering becomes both the responsible person and the designated owner. Once registered, the responsible person can transfer the horse to another person to be a responsible person. The responsible person can also transfer to a new designated owner. Okay, if you're following that, a question that we've been getting is some trainers who said, you try to switch it out, but doesn't it go like an email request to that owner to accept it? What if the person doesn't accept being the new responsible person, like if you've been fired?
Then that's something, so the person has to accept for it to be transferred. And if there's an issue, you just need to essentially notify us, and we will manage it in the system. If you're no longer, yeah. Sure. Sure.
That owner sent and to be accepted or rejected.
Yeah.
And the trainer accepted it, and it went in his account or file.
Right.
But when you, like Sarah said, when you try to, a trainer's registered and an owner's not, you have it on the website, invite, email invite owner. And every time for the last month and a half, we've tried it, and your little red bar slides across, or the software, not you.
Right.
And you can't do it.
Right.
So that, none of us see how it's going to be, by July 1st, everything. And trainers are trying, owners are trying, they're calling, they have so many questions about just the registration.
Okay.
And the only other thing I want to say, and I can't imagine your emails, because I can't imagine, but you're saying you'll answer every question. If we could get the technology person's email, because we've called many, many weeks.
Absolutely.
20 different people that I know have called, and they're very friendly. They're very nice. We ask a question. They kind of just repeat it to us, and they say they'll get back with us. And I can tell you the dates of the times I've called, and it's been over 3 weeks. I've got not one call back. Some farm managers, some owners have called. And so that number needs to be done. It says HISA assistance, and it gives the number. So we don't need to leave that on there, because nobody's getting called back. Maybe somebody has, but the people that I've talked to haven't. So can we get that, the Steve or the technology person?
Absolutely. So my understanding, and again, I'm definitely not on the help desk, and I'm not the one who's responding to the technical piece. But we have, and Steve has responded, my understanding, to the vast majority of people. We've resolved it. So we will definitely resolve your situation, and I'm sorry for your experience. Okay. Right. Yeah. So if I can maybe give Steve's email address, or so it's Steve, STEVE .Keech, KEECH @HISAUS.org. And if you can copy me, which is Lisa, LISA.Lazarus, LAZARUS @HISAUS.org. I will make sure that it is resolved within 24 hours. You're welcome.
Ok, nomás tengo una pregunta. Si piensan cambiar las reglas, ¿se van a quedar las reglas o van a estar como California, back and forth, back and forth? The rules be rules, or they go like California, back and forth, because I was in California when the rules changed, and the rules was back and forth, just made the people confused. That's the question I have. Plus, I hear they say no supplements, no vitamins on the horses 48 hours before run. When but vitamins, supplements, the horse, they tasting that, and the horse left the foot when we don't put some supplements. So the horse don't got power to run the next day. because we just cut the vitamins 48 hours before.
So on this 48-hour before thing, I need to consult with my vets and get a very clear answer to you, and I will get that within 24 hours, and I will ask Gary to circulate it. So that's one. And on the rules changing, we haven't started yet, so we're not changing rules. We've only delayed implementation of some rules.
Okay.
All right, so we've got several questions on Zoom.
Yeah. Yeah, real quick, and we're trying to know not to get into the weeds about registration, but I think some of these are the thing, because we heard this on another Zoom.
No, please go
My
ahead.
horses are registered, but I'm getting a no next to the thing. Will this disappear July 1st, or am I missing information?
This is an easy one. So the way the rules were originally written, this is another thing we delayed implementation based on horseman feedback, is that the rules require a number of vaccinations, including rabies, which a number of horsemen either hadn't vaccinated their horses for rabies, or didn't want to, or certainly wanted a longer timeline to do so. So we delayed that implementation until January 1. The only thing that horsemen have to do now is the Coggins blood test and insert that value. The system is still showing can't race due to the vaccinations, but that's going to change by tomorrow. So as long as you have the Coggins value in there, all those will change to can race, unless there's something else wrong, but it's almost always going to be the vaccination issue.
And if other people have questions here while I'm going through these, please just see, okay, let me just ask one more question here. Okay. I think this will be fast. Do you have to register as both a veterinarian and an owner if you practice and also own your own horses?
So it's only one registration process. And just so everyone knows, it's one registration for life. Like you register with HISA once, you never have to register again. It's not an annual registration. There's obviously no fee to register. When you begin the registration, you'll be given, I think it's like on the third screen, a number of boxes to choose from in terms of the roles that you play. And if you're both a veterinarian and owner, you just check both boxes.
I don't mean to continue to harp on the administrative side of it. I apologize, but
don't worry.
We have a lot of horses, and we just want to be able to do things properly.
Sure.
It seems like there's a lot of redundancies and things that you're asking of us, that programs that we already have in place. So the movement of horses, well, every time a horse leaves or enters the stable gate, there's an in and out slip, which Churchill Downs, I assume, keep track of to know what horses they have on site and what horses have left their facility, as well as changes in ownership and gelding. Those are all things we report to the Racing Commission, the racing office, as well as the jockey club. So now we are having to double our workload and report all of these things to you. Is this not something that HISA could work with the racing commissions as well as the jockey club to alleviate some of the additional workload on the horsemen, since we work enough?
Sure. So you don't have to, on just the first part of your question, you don't have to record when a horse moves. So that is a system we actually are linked to Encompass, the jockey club system. We also are linked to some of the ARCI databases and stuff. So we're trying to get as much information as possible to make it more efficient. And that may take a little bit more time for some of those efficiencies to be realized. But we are doing that. And also the vets can still use Equitaps. I think that's the right program. So we are really looking to do that. And the reason why we ask everyone to enter a racing license when they register is so we can talk to all these systems and it auto populates for you to try to make it a better user experience. I know we're not perfect, but we're really actually trying to do all those things. So we recognize that, and it's something that we're working on.
Let me ask a quick question. Last week in a webinar, Tom Rooney, who's the executive director of the NTRA, made a statement that by registering, a horseman doesn't waive any rights guaranteed by the U.S. Constitution, that HISA doesn't overrule the U.S. Constitution. Would you agree with that?
Well, HISA is not a state actor. So if HISA goes to investigate like a covered horse, whatever, we're not a state actor, so we don't actually trigger those Fourth Amendment issues. But that being said, we have the rule as it's redrafted restricts those search and seizure rights to an investigation into a specific covered horse or a specific covered horse race. But I would agree that, of course, the Constitution doesn't override HISA.
Well, does that mean if you come for an investigation to a farm that the owner has the right to demand a subpoena to see what you're there for?
It really, I think it really depends on what's in our rules, but I really am not concerned about that situation. Yeah. Okay. Sure. So, okay. So let me, if you're asking a hypothetical, I'm happy to address that in more detail. So let me start from the beginning. There's, when Congress wrote the HISA Act, they included a search and seizure provision that's similar in scope to Kentucky's Horseracing Commission search and seizure provision. It's a standard clause you would have in a regulatory authority. Okay. We heard from a lot of horsemen, people that they didn't like the breadth of that provision. So even though the FTC had approved it, we voluntarily limited it to a covered horse and a covered horse race. So no, we will not be going to private farms and demanding information. Yes.
That's still proposed. The FTC has not approved that yet.
But we have publicly said that we are going to act in accordance with it, whether or not the FTC approves it ahead of July 1. And I will say that again.
Question right here.
Yeah, the question would be, as far as, the concentration has been on like your owners and trainers. And then they say, as far as the backside workers, as far as they recommend or suggest trying to get everyone signed up. But is it going to be enforced about everyone like that grooms, hot walks, things that do not register? Is there going to be an enforcement about, they're not allowed to come to the track and work anymore? Or how is all that going to be done?
That's a very good question. So a couple of things. One is state racing commissions will still control access. So nobody will be prohibited access to a backside because they're not registered with HISA. That's not something that we regulate. The second is that the enforcement of the registration will be done this way, and it will not. So the enforcement registration will be racing offices can continue to take entries of non-registered horses and covered persons. However, when they take an entry of a non-registered horse or covered person, there'll be a flag that'll come up that'll say can't race. That only applies to the horse, the trainer, and one designated owner. Okay. And if they don't get registered by race time, so we're trying to build in a warning system, then the horse will be scratched. Okay. If the jockey isn't registered, you just need to substitute the rider. But there will be no consequences for grooms or backside workers not being registered by July 1st.
We got one in the room before we go to Zoom.
My question's about icing and nebulizing. You said earlier that it falls back to the state vet rules, or is that
that's in that bucket of things that I need to confirm, and I will confirm with Gary through our veterinary experts.
Okay, thank you.
Yeah.
Lisa, let's back up what you said about the grooms and the hot walkers.
Yeah.
They're not going to scratch. Is that going to be the case forever, or are they going to have to be registered?
No, they're going to ultimately have to be registered. But we recognize like what a heavy lift this is for everybody right now. And we are focusing on the essential covered persons around the horse so that we can get everything essentially moving properly. We give people time, especially we recognize that there are challenges with getting a lot of the grooms registered. We've done outreach, we've worked with chaplaincies, but we don't want to put that group of backstretch workers in a difficult situation. So we're going to give more time.
A lot of these people live on the backstretch. They have no access to a computer.
Yes.
Some of them don't even speak English.
Yes.
And who's going to be responsible for them signing up? And what's going to happen if they don't sign up?
So as I said, right now, nothing's going to happen. And it's something that we're working with the chaplaincies and other groups to help get them registered. And there are a number of horsemen's groups that have sponsored, registration days, like the New York horsemen's group. NIFAD did a big registration day and helped other grooms get registered. So we're going to allow time for those programs to roll out and for us to work, especially with chaplaincies, to make that happen. But there will be no consequences come July 1 for backstretch workers that aren't registered.
What about come January 1st?
We will continue to communicate with you well ahead of time if things change. Sorry?
Got another
Okay,
question?
I'm sorry, I can't.
Somebody hold your hand up if you want to ask a question.
Get a few off
Yeah,
Zoom
but
while the mic's coming back.
I just want to follow up on feedback I've gotten from a lot of trainers. They said if at scratch time, if the horse, the trainer, and a designated owner are not registered, the horse will be scratched. Are you all going to enforce that for the races July 1st?
Races after July 1st, yes.
So July 2nd on.
Correct, yes.
Okay, and because in one of the meetings.
So owner is so if there's an ownership group of 10 people, only one has to be the designated owner. So we just need to have one owner per horse registered.
Because on one of the meetings, it might even been the Churchill, it was kind of indicate there'd be a grace period on owners and not the trainer or the horse.
So there's a grace period for anyone who's not a designated owner. We're not say grace period, but they're not going to be any consequence with regard to the horse racing if an entire ownership group isn't registered, as long as there's one designated owner registered.
A Zoom question. If a horse has 3, I think they mean bouts of unsoundness in a year, are they banned for life as it says in the rules?
If that's what it says in the rules, then I don't think it says banned for life. I just reread them this morning, actually. 3 bouts of unsoundness and it says banned for life.
What constitutes unsoundness?
Can I clarify that? That's one of my veterinarians that is asking that question, meaning a NARV veterinarian is asking that question. So it says in the rules on 3 bouts of unsoundness. That's a reasonable thing if they're trotting back after a race and the regulatory veterinarian puts them on the vets list. But now that the regulatory veterinarians or the HISA is getting our medical records, and I go to a farm and I got a covered racehorse with a stone bruise, is that one incidence of unsoundness, or is it restricted to the regulatory veterinarian seeing the horse jog back after the race?
So the regulatory veterinarian in Kentucky will be the same regulatory veterinarian because we have an implementation agreement with Kentucky. So
that's not answering the question. The rule says the first bout of unsoundness will result in, I can't remember the time frame, 2 weeks on the vet's list. The second one is 6 months, and the third one is banned for life. But at the same time, I'm saying I'm sending you, the practitioner is sending you records that say, I examined horse Fluffy today. It had its first work 2 months ago. So it's a covered horse, but it's now been turned out on the farm for an unrelated reason, but it came up with a stone bruise. That's an unsoundness. You're still getting that record from me. You're still getting that turned in. Does that automatically result in the 30 days on the vet's list? Because now it's no longer on the racetrack. It's not a racing injury. It's not the regulatory veterinarian making that determination. It's the attending veterinarian making the determination. Because I assure you, most horses will be lame for a day for a stone bruise 5 times in a year. So you're just about to ban a whole bunch of really suitable for racing, sound for racing horses.
So I have 2 responses to that. One is at 6 p.m. today, we're hosting a webinar with the American Association of Equine Practitioners, and the top HISA vet and other HISA vets will be on that call. I will be as well. And I would encourage anyone who's a veterinarian to join that call. And if you need the information, please let me know, because they'll be able to address those questions better than me. The second point is that we have both regulatory veterinarian and attending veterinarian handbooks that I will also ask Gary to circulate that will answer, I believe, those questions.
Another Zoom question. What are the ramifications if a trainer does not turn over their vet, supplement, etc. records when a horse is claimed? Who enforces that, and how is it going to be tracked?
So it will be enforced by either, so in states where we have an implementation agreement, it will be enforced by whoever the state has appointed, usually the I guess the regulatory veterinarian. In states where we don't have agreements, it will be a HISA official. We will track it through the system, and there'll be an enforcement proceeding if it's not complied with.
I know there's a lot of concern from the people that do the therapy about some of the techniques that are they legal or are they not? So here's a couple of questions there. This is from one of the top equine therapists around here. Use of electrical therapy. Would it be possible to reword the paragraph regarding equine therapy? Quote, use of electrical therapeutic devices, including but not limited to pulsed electromagnetic field, laser, electromagnetic blankets and boots, electric muscle stimulation, infrasound, therapeutic ultrasound, and any other electrical device that may produce an analgesic effect is not permitted within 24 hours prior to horse's scheduled post or state vet scheduled breeze or work time. The current paragraph lists electroshock therapy. In my 33 years as an equine therapist, I've never heard of this modality being used on an equine athlete. So I guess that's just for informational. I don't think. Can you email that to me? That'd be great, because then I'll pass it on to the vets. Then here's another question. Basically, they're saying they understand the need for safety. I'm trying to find the exact wording, but they don't understand why some of these things that are helpful to the horse, why are they being ruled off, 48 hours from a race or 48 hours from, from a work? Yeah. So again, the veterinary questions are really like best, and these are decisions that the vets on the panel like debated for days and days and days, and these are the conclusions that they came to. I'm not qualified, as you've obviously been able to all see, to answer those questions. I can either take them back and come back to you, or also, as I said, we have this webinar tonight.
Can you list the veterinarians on this panel that you keep referencing?
Sure. Sure. So Dr. Sue Stover is the chair of the Racetrack Safety Committee. Mary Scalay has been heavily involved in developing these regulations. We've got Dion Benson has been involved. So we have that, that's 3. There have been more that they've consulted. We've consulted at length with the AEP, Jeff Burke. Larry Brownledge is on the advisory council. We
know who they are.
Yeah.
Great, thank you. I'm sorry, you got a question in the back?
Back to what Mitch was asking about. I mean, Hispanic people are already scared when you say government. So now you're asking these people to register with the government under HISA. I spoke with a gentleman that's a trainer in Florida a few days ago, and he said they have people leaving because the Gulfstream in particular is trying to really push the people to register, the backside help. And he said, we have people leaving left and right just because of it, because they're hearing government and they're scared to death of it, and they're leaving the workforce. And we're already short our workforce.
Yeah. So a couple of things on that. One is, we're obviously not the government. We're a private entity implementing a federal law. And I've told, I know it's only my word, so there's not much I can do other than we've said many, many times through chaplaincies, through any liaisons that we have no connection to the INS, the Immigration Naturalization Service. We have no interest in anyone's immigration status. This is a safety program. And that's also part of the reason, to be honest, why I took the decision, not to enforce on July 1 on the backstretch, because I recognize that that's a problem.
Yeah. Okay, on the blistering. So blistering is supposedly totally outlawed on horses. What about if I put fly spray on a horse, the groom does the horse up and that blisters, accidentally? Okay. What happens?
I'm putting that on my veterinary list questions. I promise to get back to you.
There's a lot of things that can accidentally blister a horse.
Yeah, no, I recognize that. I mean, that I recognize.
All right, thank you.
We got a question here, but while we're getting the mic, sure. One of the questions that I'm getting a lot, that if you can address or maybe kick it to the veterinary group, is the concern around FDA and non-utilization of products that are not FDA approved. In other words, you can't use products that are not FDA approved. Is that our understanding?
I'm not aware of a regulation that specifically references the FDA approval. I know that's something that we've talked about in guidance, et cetera. But if there's is there a specific substance or kind of group of medications or treatments that you're concerned about, because I can certainly address those. But unless it's specifically prohibited in the rules, then it's not prohibited. So.
Dr. Redden wants.
Yeah,
Sure.
I've written a couple of emails to the website. I have not got any response. They were the ones titled, "I object." You know, when you look at some of the things that they're doing, they will reference what's going on in California. We have a very broad-based practice. It handles people that come in from California and other states. There's been a move to come to Kentucky. I think we're all considering a move to Texas. I don't really understand when you list the people that have been contacted about some of these rules and regulations. They're not your everyday practitioners. In this state, we probably have 20 guys and women practicing on the backside of Churchill. Nobody's been talked to about any of these medications. You know, when you bring up something like no freeze firing, what Mr. Tomlinson mentioned about the race size going down, you don't have to wait 2 or 3 years. I can guarantee it. So it's a slippery slope when you're taking horses out of the population. And somewhere along the way, we lost the term serviceably sound. I had a discussion about a 7-year-old gelding. It's ridiculous to expect some of these horses to be perfectly sound. I had a horse that was claimed for $40,000 and made $1 million a couple of years ago. They wanted to do a pre-purchase on that horse. I advised the owner, don't do that. This horse cannot pass a pre-purchase. He can be prepared and presented and run really well. But I feel like that there's a disconnect over who's actually making some of these rules. And I know they made it a law. It's a horrible law. And if you don't talk to the people that are working every day, you're not going to get a functional product out there. It's like, do you want people to rename something, you know, to make it fit a rule?
Right.
I mean, you're not, it's just, it's not functional. The 2-year-old racing is going to be decimated by some of these decisions. And maybe somebody could send me an email back after I comment.
Sorry, what was the subject? I don't think I've seen the email. I object. Was there a question in the I object email, or was it just a statement?
There was a couple questions in there and some comments, you know, but it's like, you know, I work with Dr. Bramlage very well. Dr. Bramlage is not a racetrack practitioner. I've also had I've had contact with Dr. Scalay. The people I'd like to hear from is Dr. Fisher, Dr. Northrop, Dr. Johnson behind me, those type of people, you know, and when you're talking about things like pin firing, okay, in 1986, when I graduated, it was an archaic form of treatment that was not to be proven to be beneficial. Clinically, there are some benefits to that. And so you're not getting a permanent repair to a horse with shins, you're getting less than. So what you're doing is promoting 2-year-olds to race that are going to be less sound, more likely to be injured. The riders are more likely to be injured because not only do you take away pin firing, you can't blister the horse, you can't freeze fire the horse. You know, if somebody says, what's a splint? Well, a splint's a periostal reaction between the metacarpal bone and the cannon bone, maybe between the third and the fourth or third and the second. You know, if you freeze that area, 3 days later, that horse is comfortable. So, I mean, it is absolute foolishness to think that it's not going to impact the field size. And I'm more and more, I'm thinking about Texas or retirement. Is that your goal? You know,
it's definitely not my goal. It's definitely not my goal. And I appreciate your comments. You know, obviously we just, you know, HISA's position disagrees with that. And there, you know, and the AAEP's position on freeze firing is also that it should be prohibited. And so we're aligned, I guess, with them, but those aren't decisions that obviously.
The AAEP is too broad based. When you look at the AAEP, you need to be talking to the group of people that work at the racetrack. You know why you don't talk to them? Because they're always working. Day before yesterday was 17 hours for me. You know, and I have clients from Canada to Japan to Saudi Arabia to England.
Thanks, Doc. Julio, if you can get that in mind, go back here to the back. We've got one question up front here.
I just want to follow up on the FDA approved. It's any FDA, this is S0 under the prohibited substances section of series 3000. It says any FDA approved or any non-FDA approved medication is prohibited. Yeah. And the biggest problem with that is because I had this argument with ARCI, RMTC, as they tried to throw this up repeatedly. FDA approval doesn't mean not being FDA approved doesn't mean you can't use it in practice. By restricting our practice to FDA approved medications, we can do nothing.
Yeah, no, that's so when I was asked the question, I thought the question was in respect to the racetrack safety rules, which are operational July 1. Those rules are still in public comment. So I will either make that public comment on your behalf, or you can make it, because it is an issue we're gonna debate and discuss. That is not a final rule. These are the rules we're still discussing.
Two questions right here in the middle. Go ahead.
Okay, what's the purpose of having all of your help registered?
Sorry?
What's the purpose of having all of your help registered?
So, I mean, the way that the act is written, anyone who's a covered person needs to register. So ultimately, everyone on the backstretch will need to register if they fall in that definition. But what we've determined is that we're not going to. So, why? Because that's how we manage the program, communicate with people. That's how we essentially, in any essentially sporting industry, you have the regulator is able to communicate and basically understand the universe of participants. And that's what it's for. It's for research, it's for communication, et cetera. Yeah.
My question's about the track surfaces. What emphasis are there to ensure safer surfaces, which cause, in my opinion, the majority of the issues that trainers face is inconsistencies in surface. I mean, if you look at human sports, take what was it, the Washington football team, where how many players got hurt playing on that field? They almost wanted to boycott playing there. Are you guys going to go the way of California in terms of if there's a forecast for a rain shower, we're going to cancel racing or postpone racing?
So we have a very significant emphasis on racetrack services in the 2100 series of the racetrack safety program. And we're working with Mick Peterson and others to essentially go track to track and help them with their services. There's a phase in for the end of this year, because obviously we can only go when the track is not racing. Otherwise, you can't really properly test the surface, et cetera, and work with the racetrack. But we're going to be starting with the tracks that aren't racing at the end of 2022. And then ultimately we'll get to everyone by the end of 2023. But there is a significant, and there's a fair amount of resource that's being put into the racetrack surface improvements.
I had a question to sort of help out this individual. With the funding shifting from private loans that you guys have been running off of up to this point, so now that you're going to be receiving public funds from every state that is enrolled, are we going to get a transparent and a budget? And because my understanding is that the current budget that has floated around, somebody had to file a Freedom of Information Act request to get it.
That's not correct.
If our money is being spent, are we going to see every dime accounted for in a very transparent way every year?
So first of all, nobody had to file a Freedom of Information request. The budget has been public for 2022 for a long time, was sent to every racing commission and every racetrack. The act requires us to submit our budget on November 1 of every year. And so we will submit our budget for 2023 by November 1. Yeah. On our website. The web, it should be up there. It might have been Margaret. Okay. Well, it's definitely public, and anyone who's asked for it has received it, and it was sent proactively to the racing commissions and the tracks, but I'll make sure it's back up there.
This one here, it's kind of later on down the road.
Sure.
So say we get to going a year or two down the road, what would be the procedure if we see that a rule is bad or is basically like they're talking about hurting field sizes, something like that? What would be the process for getting that changed and the timeline?
So the authority has the the ability to change rules on an annual basis. And what we will do, and I'm glad you raised the point, is we will communicate. So right now, let me just say that on the Antidoping Medication Control Program, the rules have been up for public comment for a couple of weeks. They're still up for public comment. We're still taking communications on those rules. Okay. And then we'll submit them to the FTC for approval. The FTC may ask for some changes. Whatever results from that process will be communicated at the end of the year, and that will be effective January 1. What we'll do for the racetrack safety rules is we'll engage in a public comment period after they've been in place for a period of time so that we can take comments into consideration for the next series, and we'll make revisions if things aren't working. Sure.
In the actual law itself, is there an actual mechanism that puts a timeline on it?
No, there is not. We have to develop the timeline.
Okay.
Yeah.
Earlier, Eric asked you how much it was going to cost to run the veterinarian for next year when the veterinarian rules come in for what we got to do. You said you didn't have a number, but then you just told us you got a budget for 22. So why wasn't you tell us the budgeted numbers that you've budgeted for 22, what it's going to cost us for the veterinarian side of this?
So I think maybe there's a bit of confusion there. The budget for 2022 is out, and that budget includes it's about 1/3 racetrack safety program, about 1/3 like HISA office and operational costs, and 1/3 ramp up for the Antidoping Medication Control Program. We don't yet have the budget for 2023. That will be finalized as required under the Act by November 1. That will be made public November 1 or by November 1. So when you asked me the question about the veterinary doping stuff, I thought you were referring to 2023, and we don't have that budget yet. We only have the current budget.
Yeah, but it starts 22, January 1, 22. So it runs next year. We should have numbers. You should have numbers on what you project it's going to cost for 22. And we do. And those are public. So we have the numbers that for what we're spending in 2022 to launch the doping program in 2023. What we don't have yet, and we're not required to have yet under the statute, is what the numbers are going to be for 2023. So in other words, 2023, January 1 is when the doping rules go into effect, not January 1, 22.
Correct.
Okay.
Well, it's June 2022.
I think he means July.
July.
But,
right. Yes. Doping rules don't go into effect until January 1, 2023. Yeah.
Or if you overspend, are we going to see our costs go up the next year? And if so, is there going to be a cap? I mean, is this just going to be a slippery slope where, we spent too much money, raise up the limit to the HBPA, and we got to come up with another, year to year. We don't need to see a constant increase in terms of your budget. Obviously it's probably going to go up with more that you implement, so on and so forth. But at what point is there going to be some kind of a cap in terms of the horsemen's, accounts, daily accounts isn't going to get depleted in terms of to pay just for the Equine Safety Act?
Right. So the first question is the easier one, which is that if we underspend, what will happen is that the states or the racetracks, depending on who's paying in that state, will get that credit that will carry over to the next year. And then obviously that will be a credit on their account. It will go against any future payment. In terms of overspending, we're held to our budget. We have, with the contracts that we have in place, especially with the Center for Drug-Free Sport, which is going to be the biggest budgetary number, given that's going to be running the whole doping program, is we have very strict caps with them on what the budget is and how much they can go over and what that triggers. So there are protections in place that prevent us from going over the budget by any significant margin. I think there's like a 5% allowance, but I don't plan to go over by 5%. But I think that's the cap that we have.
Another one of the questions, Keith, sorry, one other question that we touched on briefly. Within the definitions that we have race period. And again, that 48-hour period of time includes workouts. Now, I believe you said the term public workouts. So again, I think it is still unclear for what can or cannot be permitted within the 48 hours. I still don't think that part of the question was answered.
And that's as I said, something that I'm going to have clarified by the vets and communicate through Gary and hopefully you, Eric, as well. And anybody who wants.
Let me give you one more for that list.
Sure, please.
For us, the understanding is now under normal procedure, if I want to issue a box of GastroGuard to a stable, we can do that. The way it's interpreted now is essentially every label will every label will have to have a prescription with the horse's name on it. In my opinion, that takes away from the designation of livestock that the equine have in this state. If you start getting into domesticated rules for horses, that's a pretty slippery slope. But it's our understanding. So again, correct us. We don't see any livestock provisions for RXing something to a barn. Is that correct? It has to be designated to a horse.
So I'm gonna have to defer also to our veterinary experts on that, because I'm not comfortable answering that question. Okay. But I will get the answer for you.
Keith.
So if I've kept up with this right, the number of questions that's actually been answered here compared to the questions that you've deferred, moved over, and we're to be done by July 1st, the unanswered is way outweighing the answered here.
So the questions that I'm not able to answer are some of the specific veterinary questions, and those have been answered in other forums. But I should have brought. I looked at the questions and I didn't see that many veterinary questions, and we're all divided up, speaking to so many groups, that I should have brought a vet with me, one of the vets with me. But I will promise to answer those very quickly.
And we didn't answer that one.
Sorry.
We got Jenny, you got your mic. We've got Tom, Doc. We'll take a couple off of Zoom and then get these two in the back.
Okay. We've touched on this a bit, but this is something I'm hearing a lot. If a farm provides layup veterinary work on a racehorse, is the farm responsible for providing medical and treatment records, or the registered horse owner? And I want to add on to this. I think one of the things from listening to these various meetings, if the farm doesn't have published works, it could be a not covered. So what's the responsibility? And what's the responsibility of the trainer or the practitioner when that horse is at this non-covered farm?
Right. So at that non-covered farm, it's the veterinarian who's tending to the horse that's supposed to upload the records.
Even though he may not be a racetrack vet?
He may not be a racetrack
vet.
Not if they're not licensed.
So if they're not licensed with the state racing commission, you mean?
Correct.
Yeah. So we have a provision, a separate designation for that group of veterinarians in the registrations, where they register as non-covered persons so they can ultimately upload the records. And it's the trainer's responsibility, or owner, whoever's the responsible person, just to ask them to do so.
But what if it's somebody's personal farm? Because this came up on Indiana, and the woman was an owner, trainer, breeder, but there wasn't work. So he said that her farm was not covered, but she was talking about having Banamine in case a horse colics,
right,
and maybe needing to have a syringe. So are those records that have to be, the horse is covered, but the farm's not?
So that's a different question. So I think maybe we're mixing two questions, but let me answer one and see if this helps. So there was a lot of concern and discussion that farms that are not in an official facility wouldn't be allowed to have medications or syringes, et cetera. And that's not true. If you're not a racetrack or an official training facility, those rules don't apply to private farms. Okay. Where I think it gets a little bit more complicated is, or why maybe the question is being asked, is that if you have a covered horse that goes to a private farm and receives a treatment or receives a surgery, et cetera, those records need to be uploaded by somebody to the HISA system in order to keep track of the veterinary treatment of the horse.
But who's responsible for that?
Well, I want to touch base here a little bit, because John Roach has said multiple times on the meetings that I've been on and I think I was the only one that addressed on the website the fact that there is even an allocation for non-covered persons to be registered. John Roach is the general counsel for HISA. If you're not aware, he was a former racing commissioner. Also very easy to access if you want his email. But he has said multiple times, if you are not licensed in the state under racing jurisdiction, you don't have to register.
That's correct. That's
okay.
Absolutely correct.
So then now we don't use the term attending veterinarian anymore because that's a covered person. Mm-hmm. We've got a horse that ships to Adena Springs with a layup, and my farm vet is taking care of it. As I understand it, or if I was the trainer, as quick as that horse walked out of the barn, I would change the designated responsible person to the owner. Mm-hmm. Good luck getting Frank to do anything. But at the end of the day, that owner becomes the responsible person. So you're now saying that the non-registered farm vet practicing on a covered horse has to upload the information.
No, that's a little bit. What I'm saying is that the response. Well, no, let me clarify. We've created a process to facilitate them to be able to do that if that's what's requested by the trainer or owner. But ultimately, whoever is still the responsible person has the responsibility of making sure that happens. So what we heard from trainers is that this happens sometimes. How is this going to actually work? So we created a different designation for non-covered persons who are veterinarians who are just able to log on to the HISA website and upload the records or use Equitaps or whatever they're used to using. But the responsibility stays with the responsible person.
So hearing that, if you're a trainer and you ship a horse to Root and Riddle for surgery or Haggard's, that vet is going to be responsible for uploading the information. But I would get your name off the responsible person category as quickly as possible. That's a piece of advice from Eric. Because at the end of the day, the veterinarians that are at Root and Riddle, they're not licensed by the state, and you've got surgery. Do you know what occurs to the horse? Correct. They're not going to do it. Correct.
So I just want to make sure that I'm understanding the comment because it's important. I mean, I'm not just here to speak and not listen. Some of you may not believe it yet, but I really am listening and I want to hear. So what you're saying is that there's going to be a prohibitive cost for you to get somebody at like a Root and Riddle or a facility that's not licensed to upload the records. No, I'm really just wanting to hear your comments so I can take it to my people and see if we can find a workaround. That's all. Yeah. Right.
By us and sent to a farm, or they come back if it's not a serious problem. And the only thing that they're going to do for us is take care of that horse.
Right.
Is HISA going to make sure that they upload this? Because I cannot make sure they upload it.
Okay.
And also regarding an owner having to upload information if they fire us or if we're trying to enter their horse. I have elderly owners.
Yeah.
They do not get on the computer.
Right.
I do not have time to do anything but what I already do. So you're putting a lot of pressure. This HISA, not you, putting a lot of pressure on trainers. Number one, we have our hands full, and we are already responsible for the horses that are in our care. And I would say the majority of us here love the industry that we're in. We do it because of the love of the animals that we take care of, and we're not in it to cheat. And there's so many changes that are coming about in such a short time that the horsemen had no idea. We thought that the HISA was for medication reform, safety issues. And I think all of us are on board with getting everything across all jurisdictions. We're all be on the same page, and that's awesome. But then comes all these rules that we have to just immediately start abiding by, or you're holding a gun to our head and saying, choose your livelihood or sign away a lot of constitutional rights as a U.S. citizen. I should not be forced to make that decision within 1 month. We did not know all these things were coming about. I think it's very unfair if there are not hard lines where you say, okay, these are the rules, not to, I have to refer to somebody else because we don't know, we don't understand. How are we supposed to be able to feel comfortable about signing away our rights for due process, for a jury trial? Who does HISA answer to? I don't understand that. As our commission, do we even need a racing commission anymore? They're the ones that we know they have a structure for fines when we have an infraction, trainers, jockeys, they have a structure for suspensions. Who is going to be levying those fines on us? They could be, instead of a $500 fine, could be from the government a $50,000 fine, $10,000 fine. We don't know. Is there a structure of infractions and fines? I mean, we need to know those things before HISA makes us sign to consent to things that we do not understand and we do not know, and neither do you.
So first of all, so I'm more than happy to answer to all of your points. So first of all, the law was signed into effect in December 2020, and the racetrack safety rules have been up and available on our website for a very long period of time. So I'm sorry that you're only learning about them in the last month, but they've been available for a very long time. In terms of, the constitutional rights question, I mean, this is a federal law. You're not giving anything up by registering. The federal law applies to you whether you register or not. The enforcement rules and fines, everything is available on our website. It's very clearly set forth what the fines, et cetera, are. The questions I've deferred are either, ADMC questions that doesn't take effect until January, or they're specific veterinary questions that are better answered by a vet. We are, as everyone said, we are doing our very best to communicate what we can with everyone that we can, given the timelines. But it's what the government said. And I think that the decisions that we've taken in terms of delaying enforcement in a number of areas to try to get everyone educated, I think shows that we recognize the challenges that people are facing. And I think, I'm going to take the comment that you just made back to our people about particularly about this area of requiring non-registered vets to upload documents and the challenges that people will face with that. I think that's a legitimate concern. All I can really say is this is what the federal government has imposed on us. The federal government could also close down horse racing. So we are doing everything we can to comply with the law in a way that we think is most sensible. Where we make mistakes, we're going to revisit it. Where we're creating really insurmountable obstacles, we're going to look at it and try to find solutions. I recognize there's a lot of anger and discontent, and I get it. I've been in Louisiana, I've been in Texas, I've heard it all. But all I can say is, this is the law. There is not, I think that the amount that's going to change is not going to be as significant as you think on July 1 because of the things that we've built into the process. And I just ask to give it a chance to see where we are and to continue to feed back to us on issues that are of concern. I think that's really the best I can offer at this stage.
I don't even know what's going. There it is. On the 48-hour rule from an official training activity or a race, does that go July 1 or is that January 1 with the testing?
That's July 1.
But we don't know what official training event is according to unless our state vet says.
I actually had the same comment. Training activity is leftover terminology from when HISA was originally designed to be a multi-breed document. It was left over for qualifying races from standard breds and what they term breezes and quarter horses and everything, to where people expanded that to include routine training. And that wasn't its intent when they worded it that way. Training activity was meant to include a published qualifying race in standard breds. Since the USTA has opted out, since the AQHA has opted out, the wording, the verbiage does need to be modified since it's become a thoroughbred specific document now. Okay. And that will clear up a lot of these 48-hour misconception questions that you're getting from both the therapists, the veterinarians, the trainers. Make it more thoroughbred specific and you'll get better compliance or understanding of what people are talking about.
But the definitions of 48 hours include workouts. So, I mean, I understand your point on training activity, but the definition includes race or workout, race period.
Correct. That was its intent, was to include breezes, formal breezes for time, published in Ecobase, used as a tool by handicappers to bet as being under the same guidance regulations as a race.
Understood. Yeah.
That was their intent. That was the HISA intent. And it was meant as a broader term to include qualifying races for USTA, whatever you want to call breezes and quarter horses, turn and burns, whatever you want to call them. So that's where the terminology got confusing for people.
Thank you. No, that's helpful.
Eric, to your comment about herd health, HISA runs contradictory to a number of other federal legislation, AMDUCA being one of them, which Claire was around close to. But AMDUCA gives us the right as veterinarians to use you can't use non-FDA approved, but you can use FDA approved as a extension in animal husbandry and animal health. And it has to be an FDA approved drug. It doesn't have to be approved for the species that you're utilizing it in. So if there's a human drug out there that I think is going to be efficacious in my horse outside of the stable gate, I'm allowed to use it if I can prove safety and efficacy and the need for it. So there is some contradictory stuff, and being just a veterinarian, that's the only thing that I can comment on. The rest of the stuff, but there are situations where HISA runs contradictory to other federal legislation. And that's where a lot of this conflict is coming in, this constitutionality of search and seizure. What am I going to be subject to as a veterinarian inside the confines of a stable gate versus outside the confines of a stable gate? The herd health issue has been an issue that's been floating around on the racetrack now for a while. And how do we define a racehorse as a companion animal or a member of a herd? If I go to a trainer and his herd, his barn can demonstrate a medical deficiency that I can correct by treating the entire herd, which is what we're defining his stable as, that's again, okay outside the stable gate, but contradictory inside the stable gate. And that's where a lot of this give and take and debate is occurring. And yes, I'm on the AAEP racing committee, and yes, I've been in the room for some of these discussions in other places. So I hope some of that clarifies what we're talking about.
Yeah, that is helpful. Thank you. And I hope you'll be on the webinar tonight. Thank you, because those are actually really important comments, and we do have a response to the herd issue, but I feel much more comfortable if the vets explained it than I did. Yeah, I know. Yeah. Yeah. No, 100%. And listen, I don't want to kind of, this isn't a cop out, but I generally came after all that happened. I started in February after, all the boards were appointed and the rules were promulgated. And I am really trying, I'm not suggesting that I don't have great respect for who was appointed, et cetera, but I understand. I come from a background where I've worked, it was in sport horses, but where I've represented horsemen. And so I understand the importance, and I am genuinely trying to listen, to hear, and to make changes. So I can't, I'm being very frank, I can't do anything about what's happened before in the past, but I can change what happens going forward. Yeah, I'm going to definitely have a trainer involved. I've got to figure out how I do that and what capacity, because on the doping side, it's an independent agency, but I will find the right role. I will. Yeah.
I think some of us might say, though, it also makes a difference which trainer you put on there.
Sure.
Too.
And everyone's going to have a different opinion, right? So
right.
it's a little bit
This
tricky.
is a question from Zoom. They'd like to know who HISA has to answer to. They're making the point that the FTC rubber stamped the safety rules, didn't send any of them back despite all the comments, and they're wondering where the checks and balances are.
So the FTC did some changes, and that is who, well, so I report to a board, a 9-person board that was appointed by the nominating committee that somebody referenced earlier. And we are subject to FTC oversight. So yes, it is the FTC.
But Lisa, the statute says that the FTC can only reject or accept the rules. They can't change the rules. So your comment, they changed the rules, that's not correct.
They suggested changes to us, which we adopted.
Changes. That's
yes.
different than them.
Yeah,
changing.
they suggested changes. You're right.
Can you tell people when the deadline is to get comments?
Yes. So the deadline is the end of this month to get comments to on the anti-doping medication control rules. They've been up for a number of weeks, but if anybody has something specific they want to share and needs a couple extra days, please reach out, because we want to get it right. And the only reason why there's a deadline is because we have an FTC deadline, and we have to comply with the congressional deadlines and provide it to us. Sure.
If the meeting can we access the meeting, the vets meeting tonight, like via Zoom?
Yes. Yes, I will figure out a way to distribute that. I don't have it with me right now, but yes.
Okay. And then the other thing I kind of want to say to the Zoom people, that some of these questions really had a lot to do with specifics of registration and stuff. We are going to, all these questions we will be submitting to Lisa and Steve and Alex and whoever, and we will be posting answers as we get them on the HBPA website. We'll keep it, and we'll keep updating it as we get answers to some of these questions, and you can feel free to keep submitting them.
So another question that I get asked quite frequently right now is, well, we've all been saying July 1st, but you said earlier July 2nd. Okay.
Well,
right. So July 2nd now, if we have, I'm going to pick, I'll pick a track that has a multitude of owners / trainers / horses that are not registered. Who is going to be prepared to scratch all of those horses, and essentially will you cancel a card of racing?
So the answer, I can answer that. There's just more than one answer. So in the states where we have voluntary implementation agreements, the scratching will be done by the state steward. In places where we don't, the scratching will be done by the HISA steward. And there are even a couple of states where just based on state law, there's no authority for the HISA steward to scratch a horse in conjunction with the racetrack. And in those situations, we will be taking out enforcement actions. So, yeah. We will have a HISA steward in racetracks where we don't have an agreement. Yeah.
How can I do that?
So
no, HISA can't. Oh, I'm sure they can hear me. I mean, you can't rule. I mean, you're saying HISA can overrule a steward's in Kentucky?
Yes. So it's a federal law. So basically, what somebody asked actually earlier about the State Racing Commission, the majority of your race day operations regulations are still under the authority of your State Racing Commission. The only areas where HISA has superior authority are those areas where HISA regulates. And there's under the racetrack safety program, there's about 7 rules that are hard rules July 1 that HISA regulates. And on those rules, we preempt state law and yes, would overrule the state steward. But because in Kentucky, we have an agreement with the state, there won't be an issue of overruling. It will be the state steward implementing the HISA rules.
What are those 7 categories?
So, I mean, we've issued like multiple documents on this, and actually probably I'm happy to tell you, but probably the easiest thing also to do is to go to our website and look at the resources. And there's a trainer fact sheet and a jockey fact sheet and an owner fact sheet. Sorry? Okay. So those are, so if you look at the trainer, any new rule that affects a trainer, July 1 is on that spreadsheet. Yeah. Fact sheet. Mm-hmm. Mm-hmm. Right. Right. You object to, if you're in Kentucky, you object to the state steward, because in Kentucky, they're implementing our rules. This, well, not me, but the state steward. Well, if that in fact happens, and it's a grade 2 or grade 3, then yes. No. Sorry, it's the way the violations are classified. If it's only 1 to 3 strikes over, then there's no impact on the purse. Yes. 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 Yeah. And there are going to be manuals and everything for how that's going to work.
Yeah. One thing I was concerned with, you made a statement that a non-covered state, a state that doesn't buy into the HISA rules, that you would have a steward from HISA go in there to try to override them, and I know in one state particular, and I won't mention the name,
sure,
they can't scratch a horse. Okay?
Right. Exactly.
So what happens in that state where you're going to put a penalty on them of some kind?
So what we'll do is, so let's just take a situation, because I think this is the most likely one to happen, of a trainer who's not registered, right? By July 2nd, right? And on July 2nd, the trainer goes to race and not registered, and there's no ability, because we don't have an agreement with that state, the state steward doesn't scratch the horse. And in that state, and there's a few states that have this rule, only the racing commission has the authority to scratch a horse. In that case, we're going to have to let the race run, and then we're going to take an enforcement action against that trainer, and essentially to say that the trainer shouldn't have run, and so that result should be disqualified.
So you're going to disqualify the horse?
Yeah, and the trainer if they run not registered.
Even though they're not in a state that's covered by this?
No, every state is covered. I think there's some confusion with that. It's a federal law. Every state is covered. The question is whether or not a state wants to work with us voluntarily to implement the rules so that costs are minimized and efficiencies are realized. When states don't work with us, we have to go out and hire people to do this instead of using the existing state stewards and then charge that back to the racetracks, which is an inefficient way to do things. So in those situations, and if that's the only avenue that we have to enforce the rules, that's the avenue we're going to use.
So you're going to hire somebody to go in and make the local people pay for it?
That's what the statute says. And that's why we've put 8 trillion hours into trying to reach agreements with state racing commissions, that there aren't increased costs. And that's why Kentucky, I think, has served you all well by reaching an agreement and making it less costly. No, so there's a confusion about Texas. Texas voluntarily imposed the penalty. So the only enforcement mechanism that we have against racetracks is depriving them of an outgoing parimutuel signal. So what Texas said was, they said, we don't recognize HISA, so we're not going to comply, and so we're not going to allow racetracks to export their signal. So by doing that, HISA no longer has authority over Texas. So we're not going to do anything in Texas. It only applies to racetracks that export their signal for parimutuel wagering. That's the linked interstate commerce.
So if they don't export and the guy runs a horse that's not registered, and then you're not going to fine him or take it.
There's no consequence. There's no, because that doesn't fall within our authority. To be a covered horse race, you have to be a thoroughbred horse race that sends out their signal for pari-mutuel wagering.
Jeff.
This is on. Okay, I have a follow-up question to the whip violation rule. I actually got a call on the way down this morning from a jockey in Iowa asking about the statute of limitations on the review of the races. For instance, if an owner appealed a race to try and get a horse disqualified or a share of the purse, how long can the stewards or HISA steward go back and review that film to assess a penalty on that jockey?
Yeah, that's a jock scale question. But it's, yeah, well, I'll have to get back to you on that. It's a good question. I don't know the answer at the top of my head.
Thanks.
But it is in the steward's manual. I just don't remember it. What happens to the purse when the horse is disqualified? Yeah, I mean, that's clearly set forth in the rule. If it's a grade 2 or grade 3, the horse is disqualified from purse earnings. Yeah. So that amount of the purse gets redistributed.
Okay,
yes,
hang on.
Exactly.
Mindy, we got one question on Zoom and then we'll come back to you, Mindy.
Zoom. Are we as owners able to see what has been uploaded for our horses? Also, how far back do we need to disclose surgeries, et cetera, on our horses?
So yes, owners have access to anything that pertains to their own horses, and just by using their own login information, they can go on the site and see, and hopefully that will over time be a benefit to be able to have all of your data related to your horses in one place. The second question is, we don't need to know anything before July 1st. So you're only required to upload information from July 1st going forward. If they're registered and linked to that horse, then they can access it. Yeah. Mindy. But the designated owner will be the one that we communicate with and share information with and expect to respond on behalf of the ownership group.
Mindy.
If I may, Mindy Coleman on behalf of the Jockeys Guild.
Hi,
Sorry,
Mindy.
I know this is a horseman's meeting, but there's a couple things I wanted for clarification.
Yeah.
The penalties, it's actually set up as class 3, class 2, and class 1 being the most severe. I think there was some confusion when that kept being said about the class 2 and class 3. The other thing is, and we would argue this, and this is what we had submitted and tried to discuss before, once the stewards declare that race official, they cannot go back and change the outcome of the race.
Thank you. You're correct.
So that we have made that argument and stated good, bad, or indifferent, whatever. They can't go back once they've declared it official and look for riding violations after the race has been declared.
That's it. So I think so. You're confusing two things. What Mindy is saying is from a pari-mutuel standpoint, but there can still be an enforcement against the jockey. Absolutely. I'm saying that there can be an enforcement action after the race has been declared official, but it can't change the pari-mutuel outcome. Yeah, or the purse. Yeah. Right. Yes. I'm so okay. Yeah.
It gets changed.
Yeah.
Pari-mutuel don't always be paid out. These people get paid out all the time, but they take horses down all the time.
Yes, in that sense, it would be treated the same as an anti-doping violation would be treated. Not in our obviously those rules aren't in effect July 1. But in the same way that you'd have disqualification.
The whip rules are not in effect July 1?
No, they are.
Which one?
No, I'm talking. No, you're not listening to me. I'm talking about, I said the anti-doping rules.
That's the problem.
I think I am listening to you. Okay. Answer.
Mindy, did you have another comment?
I was just going to make one other clarification that directly impacts the horsemen with regard to the riding crop. Come August 1st, you guys are impacted by the riding crop. I know Dale said not. Your exercise riders are required to only carry the specified riding crop. That is, everybody on the racetrack is required to have The new riding crop that's approved by HISA effective August 1st. That's your exercise riders. That's exercise riders and jockeys. They've put them under one definition of jockeys, but it is include the exercise riders.
Yeah, it's not the trainer's responsibility. It's the jockey's or exercise rider's responsibility. Yeah.
That's not my, I work for the guild. I asked HISA. That's not my, I just want to make sure.
Yeah. The stewards.
All right, guys. One other question that I've asked before, and we haven't quite been clear just yet, or at least I'm not clear on.
Sure.
What steps have been taken or possibly action plans been implemented on the LASIK study that's referenced in the act? Again, I'll go back to, I'm sticking to the program effective date of July 1st, but is that in conjunction with the anti-doping and medication control program, or is it in conjunction with the act and July 1st? First part of the question.
So the LASIK study is going to be conducted in conjunction with the anti-doping medication control program. And the HIWU is currently evaluating various industry experts, and we will be, commissioning the appropriate experts sometime relatively soon. We'll take feedback, et cetera, and we'll get that study going. And then that's a 3-year process, as you know.
We do understand that. We also understand that, and this may be more of a comment, certainly not directed at you, not having been here. I know a lot of trainers out here had horses scoped a multitude of times, and we're still looking for that data. Is that data been presented to you as part of the research, or is this all new going forward with the LASIK study referenced in the act?
So my understanding is that when the LASIK study is initiated, all information and data will be solicited and welcome and sought for, and that the industry experts will then take everything they have and conduct additional research and ultimately make a decision based on all of those factors.
So all of the horses that were scoped in the last couple of years, it's my understanding now, and I think this kind of clarifies it, none of that is going to be used. All the stuff that's sitting with Dr. Bailey in Washington, most of it done here in Kentucky, we still don't know that data. And I've recently written a letter about trying to get that data, but it doesn't sound like it's going to be used in the new study.
Well, I wouldn't necessarily say that. I think if there's any data out there, they're going to be interested in having it. So if you can share with me, who has that data and what we need to do to get it, I would be interested in that for sure.
Dr. Farmer can probably fill you in.
Great.
Any other questions? Anything specific on Zoom?
One final question.
Sure.
I guess you all entered into a contract with Drug Free Sport International. They're the new USADA for horse racing. Is that contract available for us to inspect or to look at? Is there transparency there?
No, that's a private contract.
What happened to transparency? I thought that HISA was going to, that's one thing we were told, everything was going to be transparent. We're going to see how the sausage was made.
Well, I don't think those were my words. What I said was that the budget will be absolutely public. And ultimately, when you see the budget, you'll see the monies that have been committed to Center for Drug Free Sport. But there's other information in there with regards to the anti-doping program that would not be appropriate to be public. And when I also talk about transparency, what we've made clear is that there will be a website like sort of every other horse sport out there that publicly tracks, ongoing cases, ongoing violations that will be accessible for the public, et cetera. But no, that's a private contract. The numbers will be available in our budget, but not the provisions.
Well, anytime you maybe have confidential information in a contract, you can redact that information, explain it's confidential, and people want to go further, they can try to, enforce their rights further. But it seemed like that would be something that everybody'd like to see.
Is there any other questions? Anybody? You got one more, Mindy?
Oh, this is to help everybody. This is to respond to it. Just one clarification. When I said that it would be at the time of official, when the stewards are reviewing it, they make that official, they make the determination. They then notify the jock the following day, or when we have movies scheduled, whether it's the following day, following next race day. At that time, they'll make that determination once they have. So they make the assessment that they're going to call that jock in and review. And then that determination, that final determination will be made during the films. So when I said official, that's when they make the determination if they're going to call the jock in or they see. I don't know how they're going to do the number count, and I don't know how they're going to keep track of it, but that's when they'll advise the jock that they come in the following day, and then they'll make the final determination that following day. So if there is an objection that's filed, they would have to go through the normal proceedings based on number count.
And I believe they're already doing that in Kentucky. Am I wrong?
No, that's one thing today too that was said that's incorrect. The rule in Kentucky is nothing like the rule that was adopted by HISA. It is completely different. The HISA rule is 6 overhand, period. Right. The Kentucky rule is 6 overhand, period, along with from the 3/8 pull home, the jockey is able to use the riding crop in the underhand fashion as necessary for the integrity of the race and also for safety measures.
Right.
It sounds like one sentence doesn't make a lot. It changes the rule completely. So this is nothing like the Kentucky rule.
Yes, you're correct on that. The 6 strikes is the most, obviously the 6 strikes is the one similarity. And if you compare it to other jurisdictions that are, completely different, Kentucky is, at least one of the closer ones.
Well, California is actually 6, but it's 6 underhand.
Yeah.
They're the only ones that had the flat 6.
Right.
Kentucky is the rule that, but it's not anywhere. And for the stewards to go back and regulate this, it's completely different than the rest of the country and the rest of the jurisdictions. And Kentucky is not like HISA.
Right. And one thing though, that would maybe be helpful to clarify too, and feel free, Mindy, to correct me if you don't agree, but the crop can also be used for safety. There's not a restricted use if it's for safety.
The problem is, and this is something we presented to the authority and anybody that has proposed that the riding crop can only be used for safety. Jockeys as professional athletes are the ones that are on the back of a horse. They can anticipate what a horse is going to do 3 to 4, 5 strides, not always, but I'm going to say the vast, vast majority of the time. By utilizing their riding crop, they're preventing something from happening. So to even Barb, who is a respectable steward in the stand, you cannot see why they are doing it. The other thing that nobody understands for safety, or no disrespect, it's not in this room, obviously, but the people on the authority were not understanding is if you have a horse that's coming up and the hole's starting to close, or you have a gap starting to close and the jock's moving that horse through, if there is the slightest hesitation by that horse, you're going to clip heels, you're going to cause something. So jocks are actually using the riding crop for safety in that situation, but nobody's going to know it because they prevented something from happening. So that's why we, after 4 years, and quite frankly, in contradictory to what was said in the Mid-Atlantic meeting the other day, we reached this agreement with many representatives. Many people were consulted in this agreement in Kentucky. Mark Guilfoyle, our representatives, reached an agreement allowing for us to still be able to utilize the riding crop in the underhand fashion as the jock deemed necessary from the 3/8 bull home for safety and for the integrity, because quite frankly, we owe it to the owners and the betting public too. I mean, I know we're supposed to be doing safety, but that's part of the integrity. We had a situation in 2 Saturdays ago, John Velasquez, who was mentioned on the authority, who had been reviewing this rule, was in a race. He went over the limit. He made the choice to go over the limit. He knew he went over the limit. When the stewards called him, he said, yeah, but if I didn't, I would have been race fixing. So I made the choice to do it. He got penalized. He got a $500 fine for riding his horse to the best of his ability and doing what he was supposed to do.
It is worth mentioning, though, that he was the chief architect and one of the chief architects of the crop rule. He was on the racetrack safety committee, and he was, a significant voice and influence in the outcome.
He was on that committee. And at that point, he gave this exact Kentucky rule. We went many times and many hours with this specific rule. Not only that, we have strong opposition to the penalties that were adopted by HISA. he was outvoted and told that he, I'm not going to say anymore other than I will tell you that is not correct. John Velasquez was adamantly opposed to the rule as it was adopted, both to the use and to the penalties that were imposed.
Okay, well, that's not what, you know.
I'll get him on the phone right now. I have the written comments and I will tell you. And Mark Guilfoyle spent how many hours with Johnny about this specifically?
Thank you.
So anyway, no, thank you.
Okay, anybody else got any questions?
Sure.
An XT is not allowed. 2 millimeter toe and a 10 millimeter rim, outer rim is allowed. Why is that?
I'm not going to be able to explain that to you. I'm putting that on my vets list. I'm not a vet. Yeah.
Well, I want to thank all of our staff that help.
Sure.
Off. Would that be allowed?
That's a really good question.
Sure, you can.
Well, I mean, I would imagine yes, but let me clarify that.
Yeah. And we also just heard from the vets that the meeting's going to be, they want to keep it to members tonight because they want to get their members and the vets the best chance to answer questions, but it will be recorded and shared.
Okay.
Thank you.
Well, I want to thank Jenny and Joe and Sarah and Billy and Julio and Gary Pizamo for help setting all this meeting up. I hope that it's been informational to you. I know there's still questions out there and that we don't understand the ramifications of this law when it takes effect fully yet, but I think they're going to add to it as they go along. And I hope this initial phase isn't just a easing into it and then boom, gets worse. And so, and I want to say special thanks to Lisa for coming. And we appreciate you taking all this and trying to answer it. And we know that you're in a position to just trying to do things. And so we really appreciate
but
it. So
listen, I've heard all of you. There's a few comments that have been particularly, I think, impactful that I'm going to take back to the committee. And Gary's been diligently taking the list for me of questions that were not answered. And I will make sure that I have answers to all of those questions within the next 48 hours. And then I do encourage anyone, because I know there were a lot of veterinary questions that were technical, that were outside my area of expertise. But as we said, the Zoom from tonight will also be available. And anybody can email me if anyone wants to come up and get my card. If there's something that they missed tonight and they need an answer to, we will get back to them, or I will get back to you very quickly.
Okay. Thank all of you for coming. And if you've got any more questions, Marty and I are available at our office, and Eric is always available by